Can I welcome everyone to this, the 35th meeting of the Justice Committee in 2013. Can I ask everyone to switch off mobile phones and other electronic devices completely as interfere with the broadcasting system, even when they're switched to silent? No apologies have been received. Item 1, we're invited to consider item 6 in private. Item 6 is consideration of our approach to an LCM on the Offender Rehabilitation Bill. Are you agreed? Agreed. Item 2 is consideration of one affirmative instrument, the draft Scottish Charitable Incorporated Organisations Removal from Register and Dissolution Amendment Regulations 2013. The instrument makes changes to the powers of the Office of the Scottish Charity Regulator in relation to the Scottish Charitable Incorporated Organisations. Can I welcome to the meeting John Swinney, Cabinet Secretary for Finance, Employment and Sustainable Growth, and his officials, Susan Gilroy, Senior Policy Manager, and Felicity Cullen, Legal Services. It's nice to have a different Cabinet Minister, isn't it? It makes a change. Not the usual suspect. Now, can I therefore just... Well, I know it's made you laugh. That's good. Now can we... I know you want to make an opening statement, Cabinet Secretary, so there you are. Off you go. Once you stop giggling.
Well, I'm delighted to be here, convener, an unexpected welcome, although I'm slightly concerned that the title of Cabinet Secretary has been linked to suspect and the Justice Committee, so I'll share that with Mr McCaskill later on this morning. I welcome this opportunity to discuss with the committee the draft Scottish Charitable Incorporated Organisations Dissolution and Removal from Register Amendment Regulations 2013. The framework under the Charities and Trustee Investment Scotland Act 2005 to enable organisations to become a Scottish Charitable Incorporated Organisation was commenced back in 2011. The SCIO removal from the Register and Dissolution Regulations 2011 were made under the 2005 Act and set up how a SCIO can be dissolved and removed from the Scottish Charity Register. We took our time in developing the SCIO legislation because we wanted to get it right. We wanted it to be of value to Scottish charities. We wanted it to be something that would allow the Scottish charity sector to flourish. Under the 2011 regulations, we adopted different dissolution approaches for solvent and insolvent SCIOs. We tried to develop processes which are designed to meet the SCIO's circumstances. For solvent SCIOs, we developed a scheme that allows SCIOs to quickly wind up their affairs and be dissolved by OSCAR. It is similar to the voluntary winding up of a company, but without an insolvency practitioner to handle the process. This approach provides a cheap, simple method of ceasing to exist for a SCIO, and by allowing representations to be made, affords protection to creditors and any other person who may have an interest in the SCIO. The 2011 regulations have now had over 2 years to embed, and it appears that we have achieved what we set out to do. There is, however, a slight omission in that if the Office of the Scottish Charity Regulator issues a direction to SCIO to change its name, and the SCIO fails to comply with that direction, there is no provision in the 2011 regulations which allows OSCAR to require the SCIO to be dissolved. The only option currently available to OSCAR under the 2005 Act is to remove the SCIO from the charity register. This is at odds with the original policy intention of the 2011 regulations, which was that a SCIO should always be wound up prior to it being removed from the register. No other exit route from the charity register should be available. This is particularly important as it ensures that the interests of beneficiaries, creditors and other third parties are protected. All outstanding debts and liabilities should be transferred, and any surplus assets should be transferred to another body or bodies with charitable purposes the same as or as closely resembling those set out in the SCIO's constitution. This draft instrument will amend the 2011 regulations to ensure this happens for SCIOs which have failed to comply with a direction to change name, so that in future, regardless of the situation, a SCIO will be required to be dissolved before it is removed from the charity register. This instrument, taken together with other sets of SCIO regulations, create a package which is designed to meet the needs of Scottish charities now and in the future.
Thank you very much, Cabinet Secretary. Questions? Margaret.
Morning, Cabinet Secretary. Has there been any incidents of a charity being wound up or not being wound up before being removed in the circumstances you describe, and if so, what happened to the assets?
What has given rise to this situation is essentially a requirement where OSCAR wished an organisation to change its name, and the organisation did not follow that forward. and therefore I suppose you describe the situation as something of an impasse. So therefore, ensuring that, and that's what that has done, has highlighted an anomaly in the original regulations, which was at odds with the policy intention. The policy intention of the 2011 regulations is exactly the same as the policy intention that I'm setting out today. It's just that we have unearthed an anomaly in that situation, which we now wish to resolve.
And there was one instance of it then?
That's correct, yeah.
And what happened to the assets in these circumstances?
Oscar concluded that it was unlikely that the SKIO was operating or that had any assets or liabilities. So we think, in a sense, the issue took care of itself, but it highlighted a weakness in the regulations which we seek to amend.
Thank you.
Can I ask Cabinet Secretary, and because I was trying to pick it up, was if a charity under this doesn't change its name, then it doesn't come off the register until such time as it's wound up. I understand that. But you said something there about the assets and liabilities, I think, would be transferred to a charity of similar purpose. What if that charity doesn't want the assets and liabilities transferred? Let's say there's more liabilities than assets. What if they don't want it? What would happen then?
Well, essentially, what this regulation is about, Convener, is about ensuring that there is an orderly process for dealing with all arrangements and connections with assets and liabilities, and that wasn't properly and fully provided for in the original regulations. So there would be no obligation for those assets and liabilities to transfer to another organisation. What there would be an obligation to do would be to resolve all questions of assets and liabilities before the wind-up of a charity, of a SKIO was undertaken and it was removed from the register. So essentially, what the regulation is trying to do is to put in place an orderly process for dealing with circumstances where a SKIO cannot remain on the register in advance of it being removed from the register.
So it would simply be an insolvency practitioner, I take it, would come in. Is that the case? I understand what you're doing. I'm just asking, if you've got assets and liabilities, and one of the things you said was, would it be for the insolvency practitioner to say, offer whatever there was, if there was quite a lot of assets, let's say, then they outweighed the liabilities to a similar charity? Would it be for the insolvency practitioner? What person or legal person would do this?
Cullen,
please, yes.
Just to supplement, one of the things that the regulations do is that it gives Oscar the ability to just go to the Court of Session. So if a charity, a SKIO, is not playing ball with the request to go through the dissolution process before it's removed from the register, Oscar can go to the Court of Session and ask the court to do it on behalf of...
So Oscar is a legal entity in its own right. It can pursue something. I just didn't realise that.
Yeah.
Thank you. That clarified it.
And that process reflects what already happens where you've got a charity who's failing the charity test, which is a different failure by... Sorry, a SKIO failing the charity test. Again, Oscar can just go to the court and say... The SKIO is not cooperating. We want to resolve it this way.
Yes, thank you, thank you. Anybody else? John?
Quite small questions, Cabinet Secretary. I note from the report that a full public consultation has not been undertaken. Is there any particular reason why? And two, I also note that Oscar there will be associated costs attributed to this processing. Could you give us a kind of ballpark figure what that might be?
On the issue around consultation, essentially, our judgment on that was driven by the fact that there was a full consultation undertaken around the 2011 regulations, and the policy intent, as I explained to in one of my earlier answers, has not changed in this respect. It's simply that we've identified an anomaly within the regulations that requires to be addressed. So we didn't feel there was any necessity because policy wasn't changing and the consultation exercise was appropriate for actually the public consultation ran from November 2009 to February 2010, including stakeholder groups in various locations around the country. So we were satisfied that adequate public consultation had been undertaken. On the issue of cost, essentially, this is a core function of Oscar to maintain the register. So Oscar will be incurring costs in the maintenance of that role and that responsibility. I wouldn't envisage that this involves Oscar in any particularly significantly more cost than are already associated with winding up a particular charity and removing it from a SKIO and removing it from the register.
No other questions, so that concludes what was an evidence session. So I move to item 3 in the agenda, which is the formal debate on the motion to approve the instrument considered on the previous item. Can I invite the Cabinet Secretary to move motion S4M 08390 that the draft Scottish Charitable Incorporated Organisations Removal from Register and Dissolution Amendment Regulations 2013 be approved?
Move formally, Convener.
Do any members wish to speak? No. The question is that motion S4M 08390 be agreed to. Are we all agreed? Agreed. Thank you very much. Now, as members, thank you very much, Cabinet Secretary. Brief but pleasant. As members are, I'm talking about us. As members are aware, we are required to report on all affirmative instruments. Given the deadline, will members be content to delegate authority for me to sign off this report? Thank you. Right, I'll just suspend for a couple of minutes, stay put, to allow witnesses to take their seats. Right, I now resume and I welcome to the meeting Assistant Chief Constable Malcolm Graham of Police Scotland, Chief Superintendent David O'Connor, President of the Association of Scottish Police Superintendents, and David Ross, Vice Chairman of the Scottish Police Federation, as we now move on to our 7th day of evidence on the Criminal Justice Bill at Stage 1, and this is in relation to corroboration and related reforms. I thank you all for your written submissions. Good morning to you all, and straight into questions from members, please. I'll take Christian, then I'll take John, and then I'll take Margaret. Christian.
Good morning. Let's start straight away with corroborations. I've seen some evidences, written submission you've given, one from the Scottish Police Federation, where we talked about the abolition of corroboration inevitably results in the lower end cases being subject to appeal. I found that in the same paragraph where there will be a great difference in corroborations, when at the start we see there should be no blanket abolition of the requirement for corroboration, which is the exact terms, as opposed to removing corroborations altogether. So I would like to have your views on this. Is there maybe out there in the debate about corroborations a mistake in the language is saying that we are talking about removal of the requirement for corroborations as opposed as corroborations, and that removing the requirement for corroboration doesn't mean that corroborated evidence or corroboration will be taken out altogether. But
say, Christian, and I appreciate you've not been on the committee. I think everybody in the committee understands that we are not talking about abolishing corroboration per se. We're talking about the mandatory requirement for corroboration. and lessen their statutory offences. I think we can put that on the record, so that's clear for us. I think it's probably absolutely clear for the panel, but nevertheless, Mr Ross, the question was put to you, and then if any others wish to self-nominate, just let me know and I'll call you. Thank you. Mr Ross.
Yeah, I think as discussion and debate around corroboration has moved on, it's become clearer what's intended in terms of what's contained in the bill. And our view is now that we're talking about the requirement for every strand of evidence to be corroborated being removed in favour of checks and balances across the whole of the evidence and safeguards. So in truth, what our view is now is what we're describing in terms of checks and balances, other evidence supporting evidence of an eyewitness being supported by other evidence rather than two eyewitnesses. That kind of...
known it was never two eyewitnesses, Mr Ross, so we've been aware of what it is. So perhaps if you clarify, you mean every strand. Are you talking about in gathering of evidence rather than in court process? Perhaps if you would analyse it like that for us, it would be helpful.
Well, I think in our view has always been, in terms of how police gather evidence and how we report evidence, is that by and large that's done using two police officers, using two forensic scientists, and our view has always been that that was unnecessary and was costly to the criminal justice system and didn't provide any great benefit to it. And that was part of our response in terms of our view on corroboration. So we were always opposed to the blanket removal of it in terms of the most recent comments from the Cabinet Secretary for Justice and indeed the Lord Advocate suggest that we're talking about checks and balances and safeguards and other evidence. In truth, what we're talking about is corroboration from different sources rather than corroborating each, an eyewitness's account being corroborated by another eyewitness's account, or indeed forensic evidence being corroborated by some other form of evidence. And if that's what we're talking about, and my understanding is that's absolutely what we're talking about, then we have moved to a position where we'd be quite supportive of that, given that that's now our understanding of what we're talking about. Still sounds like corroboration to me. Absolutely, and it sounds like corroboration to me. In terms of evidence gathering, it's always been the police. I mean, we've corroborated the requirement for corroboration now. The police will always and have always gathered as much evidence and reported that evidence as is available in every case. The notion that we just stop as soon as we've got a sufficiency of evidence was never the case, and it won't be the case irrespective of the outcome of the passage of this bill.
Somebody else wish to comment? Mr Graham.
Thank you. Yeah, I think it's helpful, the clarity that you've provided about what we're discussing here is the removal of the absolute requirement for corroboration. We're very clear that whilst we understand certain particular facts must be corroborated before any proceedings would be commenced, for instance, identification, commission of certain elements of the essential facts in a crime, that this is often irrespective of the weight or the quality of other supporting evidence which wouldn't be considered to meet the technical requirement of corroboration. And therefore this is an unfair bar to justice for many of the victims of crime, which includes particularly certain crimes where vulnerable people have been exploited, and therefore there is an intention on the part of the perpetrators to ensure that some of the technical rules which would prevent proceedings from taking place are exploited in the commission of the very offences which we would perhaps most seek to address.
Thank you. Mr O'Connor.
Yes, and we've taken time over the last year in terms of our association to look at the debate, to engage in the debate and to be consulted. And right at the outset of the debate, we had concerns about the wholesale abolition of corroboration, and there has been some clarity brought to the debate in recent times. And I think at the outset of the discussions, we had a concern that potentially we would end up with a case where you would have a suspect or an accused and a victim, and we may be moving away from the criminal burden of proof to something that would look more like the civil burden of proof. And I think one of the key safeguards for us is that in all of this we are retaining the criminal burden of proof. We have to prove a case beyond all reasonable doubt.
Mr O'Connor, that was always the case.
Yeah.
So I'm surprised it took a year for you to work that out? I'm sorry to be rude, but
Well,
I mean, that's never been on the agenda.
Well, well, absolutely. I mean, but I have to say there has been a great deal of debate and discussion, and I have to say that right during the course of the last year, I mean, we have been seeking some reassurance that some of the safeguards in terms of the corroboration of the different strands of evidence that David refers to are actually going to be put in place.
I'll let others. Christian, do you want to ask some more on others then?
I just wanted a supplementary on that particular point, saying that do you think that the removal of the requirement for corroboration will bring more prosecutions, in your view?
Yeah, I mean, the intention behind our support for the proposal for the absolute requirement for corroboration to be removed would be that a larger number of victims would get access to justice. And that would mean that there may be more prosecutions. And we've done some exercises which would look at the position that we're in now in terms of the role of the police in conducting thorough investigations. And that's a point that I may come back to in terms of how we do conduct thorough investigations to gather all the available evidence, and exercises that we've conducted over the course of the past 2 years, which would demonstrate that there would be a small increase in the number of cases that we would report to the Procurator Fiscal based on our understanding of what the change in the law would mean if it were to be passed by Parliament. Now, that small change is disproportionately moved towards more solemn procedures, so there would be a larger increase in cases that we would report to the Crown, which under the current system we wouldn't, in cases that are likely to be heard under the sheriff and jury system or in the High Court. And a number of those cases are serious sexual crimes, and the type of cases that I referred to earlier, where the particular dynamics of how those crimes are committed and the ways in which perpetrators often target victims means that there is a lower likelihood of the technical barrier of corroboration to corroborate every essential fact being met. In a broad sense, we looked across a large valid data set, and it was going to be an increase of around 2% of the cases that we currently report now, compared with what we would report under the proposed changes. And that would represent almost 3,000 additional victims being given access to justice who at the moment the police assess there is not a technical sufficiency of corroboration for us to report that case to the Crown Office Procurator Fiscal Service. And I'm aware that the Crown Office Procurator Fiscal Service have conducted similar exercises based on what we report to them and the new prosecutorial test. And I believe that the Lord Advocate has supplied evidence of that to this committee already.
Just had some difficulty with the term access to justice. Perhaps if you would define it for us, that would be very helpful.
Well, I think access to justice is a broad term. Clearly, there are different stages where victims of crime, and that, I must stress, is one of the areas that Police Scotland is focusing on in relation to our clear role to keep people safe. One of the ways of keeping people safe is to prevent people from committing crime. One of the ways to prevent people from committing crime is to ensure that they're brought to justice for the crimes that they've already committed. In relation to access to justice as a term, I think that would include when people report that they have been the victim of a crime to the police. We do everything that we can to investigate that thoroughly. I would be very happy to describe what that means, because it's clear from some of the wider speculation around this debate that some of the people who are making comments on this don't understand perhaps the rigours of police procedure and the investigatory process. But in terms of access to justice, in broad terms, that would mean people having the opportunity for their case to be considered by the Crown Office Procurator Fiscal Service and a prospect of that being taken forward into court proceedings. Our assessment at the moment from the police perspective is that if this law was to be changed as proposed, an additional 3,000 victims would have the opportunity of their case being considered by the Crown Office Procurator Fiscal Service, where at the moment victims in those circumstances wouldn't. And I'd be very happy to supply some specific examples of cases.
Let others come in, but I think it's fine. We understand. I think committee now would understand, from quite rightly from the police perspective, what access to justice means. But each set of witnesses that's come has a different. They're somewhere else in the process and have a different line on what is an access to justice. It's very helpful. But I've got a list of people who develop it later. Let them come in. John Finney, followed by Margaret Mitchell, followed by Sandra, followed by Eileen Murray, and followed by Rory Campbell.
Thank you, Convener. I'd like to pose some questions to my former colleagues and friends, Mr Ross and Mr Conrad, about what it might be perceived as the changing position of the staff associations in relation to this issue. Mr Ross, in the written evidence we had from Scottish Police Federation, and I quote here, corroboration is also particularly important in maintaining public confidence in the criminal justice system. Now, in fairness, an earlier comment was that the SPF are not opposed to making some amendments in relation, and these related to the service of legal documents and transportation of productions. But if I also quote from another section of your evidence here, blanket removal, and this was specifically relating to police officers, but also went on to talk about, for every other member of the public, would risk exposing to more spurious and malicious allegations which would be harder to refute. What in the debate has changed on that, if anything? And hopefully nothing has.
I think, in truth, what you're quoting from there is our response to Lord Carloway's report rather than our response to the Criminal Justice Bill. And in terms of Lord Carloway...
Going to confirm?
Actually it is the...
Yeah, no, you may, yes.
It's on page 2 of your submission. It says, blanket removal of corroboration would risk exposing police officers to more spurious and malicious allegations, which would be harder to refute, and similarly so for every other member of the public. And that's page 2 of your written submission.
I think our position is and still is that the blanket removal of any requirement for corroboration would potentially expose the criminal justice system to all of those things, and indeed...
It's exactly what this is, the blanket removal of mandatory requirement for corroboration.
I think in terms of the clarity that was provided earlier on, that was not necessarily our understanding when that was written, in the sense that what we were responding to was a notion that corroboration was being taken out of the system altogether, so any degree of corroboration. And indeed, that was predicated on comments from a lot of different sources, but the notion that potentially the evidence from one source could be sufficient to convict someone, one source of evidence, whether that was an eyewitness or some other form of evidence, which for us was a step way too far in terms of the progression of this debate. What's clear now is that that's not the case, and we are much more supportive of a notion that what we're talking about here is the general requirement for corroboration of each strand of evidence, as opposed to corroboration being provided again across the whole of the evidence, then our position is that we would support the latter but not the former.
Right, but for the avoidance of doubt, Mr Ross, I mean, the function of this committee is to scrutinise the specifics of that legislation. This is the response to that. Now, there are reference has been made by more than one witness to the clarity of the debate. I don't know if that clarity came, for instance, from Lord Gill, whose position was unequivocal, or what the source of that clarity is. But notwithstanding where either you believe that clarity has come from, this is this is what we're scrutinising. It's not what you might think it is. It's specifically this, and this is your evidence in relation to the recommendations in the legislation. And I mean, does that evidence stand, or should we anticipate a further submission from the Scottish Police Federation?
It's very difficult, given all the discussion and debate that's already taken place, for me to say, you know, I don't consider that we have completely turned our position from one of support from one of resistance to one of support. I think as our understanding has grown about what we're talking about here, our position has moderated to the extent that we would support the removal of corroboration, the requirement for corroboration in general terms, in favour of the requirement, well, the sufficiency of evidence across the whole of the evidence to prove guilt beyond a reasonable doubt.
Can I ask Mr Ross, and I'll come on to Mr Conrad there, is is your evolving position, then, if I put it that way, in any way influenced by what we had as the supplementary written submission from the Crown Office and Procurator Fiscal Service, which at paragraph 33 talks about false allegations against professionals and talks about the measures that are put in place to ensure that, and it refers to police officers, teachers, social workers, health professionals and prison officers. And it says, and I quote here, again, proceedings in such cases would not be taken up without strong supporting evidence. Is that reassurance altered the Federation's response?
I wouldn't necessarily say it's that reassurance. It's been part of that, and also comments from the Cabinet Secretary for Justice, the Lord Advocate, the Solicitor General, in general terms about corroboration, but specifically in relation to the Lord Advocate's comments to us regarding, for want of a better description, checks and balances and safeguards about complaints against professionals.
No, well, I fully understand the obligation of you to represent the interests of your members, and that reassurance would be helpful. However, I do return to the phrase blanket removal of corroboration would risk exposing police officers to more spurious, malicious allegations which would be harder to refute. You may have gained some reassurance from that, but then the phrase, and similarly for every other member of the public. I presume it's not your view that there should be a higher threshold for...
Absolutely no. Our view is that it should be the same threshold for everyone, irrespective of what position they hold or don't.
Okay, thank you. Mr O'Connor, you're...
And do you still want to come in?
I'll come to Mr Graham if I may.
You're walking your way along the line,
I am indeed,
if
I may, please. Yes. Mr O'Connor, your response says, I remain not wholly convinced, so I would have that as unconvinced, of the case for the complete abolition of the requirement for corroboration. And could you comment along the line of the questions I posed to Mr Ross?
I mean, again, we have had a great deal of debate, and I think one of the things that we keep coming back to from a police perspective is in terms of policing, nothing will change. Police officers will continue to go out there and conduct very comprehensive investigation. They'll continue to gather all the evidence. They are bound by disclosure in terms of the gathering of evidence, and will report the facts and circumstances to the Crown. Nothing will change. These full, detailed, comprehensive investigations will continue within the police service.
Mr Connor, you've been a senior investigating officer dealing with very serious crimes, and we did hear, for instance, that there had been 2 murders where there was no body recovered but convictions had been obtained. Now, the basis of these convictions was the collation of huge tracts of circumstantial evidence, for want of a better phrase. Is that correct?
Circumstantial evidence, yes, can be a strand of evidence in the chain of evidence, but as can many other parts of evidence. And I think, if I can just say that, you know, what we've found during the course of the debate is corroboration can mean different things to different people. And it's not just the 2 eyewitnesses, it's the whole gambit of evidence. And science has moved forward considerably in recent times.
Yes, indeed. So I don't think you'll find anyone that would dispute that Police Scotland will pull out all the stops for a serious crime like that. And often will do so at the direction of the Crown Office and Procurator Fiscal Service, who will lead that investigation.
Yes.
But I don't think you can give such an assurance for, let's say, a minor breach of the peace, a minor assault, and I don't mean these because they can be very traumatic events for the accused. But there won't be that same level of energy. There won't be that same level of chasing forensic examination because, as you know, there are many and frequent, particularly at weekends.
I mean, evidence, as I've said, can come from a whole variety of sources, and I have absolutely confidence in the service that they will continue to seek a corroboration from whatever source, and thereafter it's a matter for the Crown to look at the veracity, the sufficiency, the competency of the different strands of evidence.
But I'm not talking about the initial response. I'm talking about, if you like, the supplementary response. We know that follow-up inquiries will take place often at the direction of the Crown Office and Procurator Fiscal Service. That's not going to happen with your run-of-the-mill breach of the peace where it may be a single individual that's accused who is a credible witness, or perhaps an assault, something of that nature.
It's certainly, I would have confidence in the service that, you know, whether it's a matter of public disorder or a minor assault or whatever, that the investigating officers would go and they would seek evidence from other eyewitnesses, from CCTV, from mobile telephones. There's a whole variety of modern ways where evidence can actually be drawn in, even for these minor matters. And if there's barely, an incident goes by where perhaps there's not access to mobile phones, CCTV for these types of things.
It's for these very reasons we've been told there's less requirement than ever before to remove the requirement for corroboration, because there are all these additional sources of evidence that there weren't historically.
Yeah, I mean, I have to say that each of these different parts can corroborate, and I go back to where I started. I've absolutely no doubt that the police service going forward will continue to carry out the investigations and to draw in evidence from whatever source it takes to put a case together, to allow the matter to be reported to the Crown, and to allow the Crown to make the decision.
So, what is the position of the Association of Scottish Police Superintendents regarding the proposal to abolish the absolute requirement for corroboration? Are you for it or against it?
I think at this particular time we are more content with the proposals in moving forward, provided that as we move forward we're quite clear in terms of what the marking rules will be, and we've heard a great deal about not just looking for the quantity of evidence but the actual quality of evidence as we go forward. And back to where I actually started, the criminal burden of proof will remain the same, in as much that a case has to be proved beyond all reasonable doubt against an accused person.
Mr. Graham, yes, sir.
Thank you. I think if you're seeking assurance, and I think you did seek assurance about what the Police Scotland position would be were the law to change, then I'm in a position to offer that. And with neither hesitation or qualification, I can say that the standard of investigation across the board would not change if this law were to be brought in as it's proposed. There is an absolute requirement on the police, with diligence and rigour, to undertake investigations to an evidential standard that's established through current case law, which wouldn't change as a result of any of the proposals that sit within this bill. And I can go through what some of those requirements are in the case law. It's the duty of the police to put before the Procurator Fiscal everything which may be relevant and material to the issue. Smith v HMA from 1952, MacLeod v HMA 1998, all material evidence for or against the accused must be disclosed. And more recently, in 2008, and the police must supply all this information to the Crown. MacDonald, Blair and Dixon v HMA, all material evidence which either materially weakens the Crown case or materially strengthens the defence case must be disclosed, of whether the suspected party is innocent or guilty. So the position in the police in terms of whether it's a minor offence or whether it's a serious offence will not change in relation to the rigour and diligence with which we will investigate crimes, gather all available best evidence. And I need to address very strongly the contention from a number of areas, and you've referred to it yourself in relation to Lord Gill's fear that the police may not go seeking corroboration. Well, we don't set out to seek corroboration at the moment. We set out to investigate the circumstances of an offence or crime that's been reported to us or that's come to us by other means. That means that we need to establish whether a crime has occurred, and if it has, we need to establish who's committed that crime. We don't then set out
on the term a credible witness, and someone can appear a credible witness.
We don't set out to gather evidence that corroborates or otherwise in terms of one strand or two strands. We set out to gather all the evidence that is available. In some cases, there will be multiple strands of evidence which would corroborate the same fact. In other cases, the cases which I referred to earlier, we know that it is extremely unlikely, because of the nature and the dynamic of the offending, that some of the essential facts will be corroborated in a higher proportion of the cases. Now, it's clear from international perspectives in relation to views on the current corroboration laws in Scotland that that is deemed to be discriminatory against some of the victims who are most likely to be victims of these crimes. And it is clear from the police perspective that it prevents there to be, in some cases, an assessment of the quality and the sufficiency of the evidence on whole because of a technical barrier in one of the facts of the charge not being corroborated technically in the way that the law is currently constructed.
These characteristics, for instance, be penetration, which is one of the 3 characteristics we heard would be required to prove the crime of rape.
If it's an essential fact in any crime, and penetration is an essential fact to be proved for rape, then at times it can be difficult to provide corroboration of that fact. It's highly likely that these are circumstances that we're talking about where eyewitnesses are not going to be present, with the exception of the victim. Additional eyewitnesses are not going to be present, and therefore finding supporting evidence is often there, which is consistent with the account that's been provided by a victim. But meeting the artificial and technical barrier in law of corroboration at times is not. And my contention in relation to our experience of dealing with victims is that that prevents, in a large number of cases where there is both credibility and there is a large amount of quality evidence, that technical barrier not being met can prevent, in the terms that I previously explained, victims of serious and less serious crimes getting access to justice. Sorry.
I'm aware that the phrase access to justice is the current buzz phrase of the moment, and it has featured strongly. Has Police Scotland made any assessment of the increased likely level of charges of false accusation of crime or wasting police time associated with any proposed change going through?
We haven't made any assessment of that, and I can explain the reasons why. I think it's interesting when we're trying to focus on the victims of both serious and less serious crimes that the debate is sometimes drawn back to the issue of false allegations. We have done work looking at how many false allegations are currently made, and the level is extremely small. I would rather that we focus our attention on actually dealing with the large number of victims of crime who at the moment do not have their needs or expectations met in terms of the justice system.
I think it would be entirely wrong to paraphrase questioning of this nature as not being supportive of victims. You wouldn't want anyone to be the victim of a false accusation as well, I presume.
Absolutely not. And at the moment, if that was the case, then
finish, please. Just then finish, John. Sorry.
We absolutely would not want anybody to be the victim of a false allegation. And as you're aware, there are cases where, when somebody is falsely accused of an offence, that is investigated thoroughly to the same standard as I've described, and on occasion results in proceedings being taken and prosecutions through the justice system. I just want to make the point very clear that that is a very, very small number of cases compared with the overwhelming and rising number of reports that we are receiving, particularly about serious sexual crime. And that's a far bigger issue to focus upon.
Certainly an important issue. We've heard from a number of witnesses that this is about rebalancing cadre. It's certainly, we also heard from the Lord Advocate that there are challenges connected with the investigation of the crime of rape brought about by cadre, and the situation whereby an accused who formerly may have indicated that this was a consensual act is now saying nothing. So one of the 3 characteristics required to prove the crime is removed. Would you care to comment on that? Is it a rebalancing?
Well, I think following Cadder, there was a requirement to examine whether a rebalancing was required. My understanding is that Lord Carloway was requested to do that piece of work, and as a result of his widespread and in-depth examination of the justice issues, legal issues that arose out of the Cadder case, he came up with a number of recommendations. It doesn't feel to me that this is a response to rebalancing of Cadder, because the issues that I am describing have been present in police investigations and thereafter the consequences in the justice system in advance of the Cadder decision being made. Notwithstanding that, clearly the Cadder decision in itself provided a different balance in the legal considerations of these cases, and therefore, following Lord Carloway's examination of the impact of that, I think it's entirely right and proper that he came up with a number of recommendations which would ensure that there was an equal focus on the rights of everybody that's involved in the justice system.
I would like John and Oh, I'll
I just
let you back
one
in.
finds.
Oh, right. Oh, because you've had a good slice.
Yes, I do appreciate
queue.
it. Thank you. Mr Graham, it's just, can you advise us how policy formulation is done by Police Scotland? How do we come to get this view as being the Police Scotland view? Is it Mr House's view? Or is it what consultation, what engagement is there? Is there engagement with the staff associations, with operational officers, which would formulate the view?
Well, ultimately, I'm here as a representative of the Chief Constable, so it is the view of the Police Service of Scotland, which is endorsed by the Chief Constable, albeit you accept he can't personally be here to offer that view on every occasion. That said, and I'm not sure if it's what was intended, the inference in your question, do we just take a view from the Chief Constable and then replicate it in any forum that we attend representing him? The answer to that is no. There is a large amount of work that is done in terms of developing an informed and comprehensive position in relation to extremely important issues, not just for Police Scotland, but across Scottish society. That involves consultation with the staff associations, which I'm sure my colleagues will confirm. That involves consultation with other agencies in terms of their perspective that we can take account of, people that we work with and that our work impacts upon. And in this case, particularly some of the organisations who represent victims. And that also includes, at times, us asking police officers to do specific pieces of work to develop proposals that would then be endorsed through the governance forums of Police Scotland and ultimately the Police Scotland executive team that's led by Sir Stephen House.
Yeah, thank you all very much.
I think the point of the question was that it seemed that Police Scotland and the Federation had different views at one point. I think that was what arose from your question to some extent. But if you're going to pull that face, I'll let you back in later. Margaret, Sandra, Elaine, Roderick. Margaret.
Good morning, gentlemen. Given there seems to be quite a movement in the position of ESPS and also the Federation of Police Officers, this is obviously quite a complex issue. We're very concerned in the Justice Committee that we don't have perhaps enough time to look at a decision, an issue of this magnitude with the kind of scrutiny that we would really like to. In view of that, would you be in favour of taking this issue out of the Criminal Justice Bill and moving it to, for example, a Royal Commission so it can be looked at thoroughly to satisfy everyone? That wasn't an option looked at under the Carloway report, where it was abolition or retention. Could I have the panellists' view on that suggestion?
I'm very happy to go first on that. I think the question of time, go back to the points I made about the other decisions that were made and implemented very quickly in the justice system. And Mr Finney related to the Cadder decision, which in effect came from the Saldus case in the European Court, and the timescales for both the decisions and then particularly the implementation of the changes that resulted from that were extremely tight and imposed considerable challenges to the justice system. Lord Carloway was given a substantial period of time to make his considerations and report to the Scottish Government. And my understanding is that there's been a large period of time since that report was made, which has allowed all of us to carefully consider, and I've described what Police Scotland do. I'm sure colleagues can speak for themselves in terms of what they've done to formulate their view and perspective, and how that position may have evolved as more information and clarity is entered into the public domain from some of the key agencies that are involved in this. I don't think that we need any more time to look at some of the issues, in fact to look at any of the issues which we've already covered today in some detail. There are a large number of victims of serious crime who are not having their expectations of the justice system met in this society.
This committee, and I think as we've resolved, whatever our views are about mandatory retention of corroboration, absolutely on the side of those victims you're talking about who are not having their day, either the Crown to consider or to be prosecuted, or their day in court. That's not the issue for the committee. In fact, the issue is, will this deliver justice for those people? I think it's put it in fairness to them. And so why we are testing you on this is, and why my colleague is doing that is, It may appear to be that we've had sufficient time, but we've already had the Federation changing their position in the course of evidence to this committee. So I think that's the point of Margaret. Sorry, Margaret, but I just want to make it plain. You mustn't please portray us as somehow not wishing to see these cases be dealt with. That really is the position of everybody on this committee, whatever their position is on corroboration. That must be put on the record. We've got people coming for us next who represent those victims and so on, and I want them to know that as well. Sorry, I got a bit, but I think the idea that we're testing you is somehow against them is not the case.
No, well, thanks for the clarification, Convener. It was not my intention to in any way suggest that you weren't supportive of victims. I think it's incumbent upon me to present the position of Police Scotland where we come from, the perspective that we look at it from, and I would suggest try and put some balance into some of the debate that's been going on more widely than this room in relation to the corroboration arguments which have already been raised by some of the members. So I note your point.
It's still unclear, Mr Graham, about what you're actually saying. I think you're saying Police Scotland would implement them tomorrow. You're perfectly happy. What I'm asking you to consider is the fact that Carla Wade, regardless of how long he took to do it, it was the opinion of one judge. Now, there's been a weight of opinion now expressing real concern about the abolition of corroboration as proposed by the Carla Wade report. So does that give Police Scotland any pause for thought? And are you totally ruling out taking this out of the Criminal Justice Bill, where it will go very, very quickly next year into law without being properly tested in something like a Royal Commission, which may not take very long, but will ensure the depth of scrutiny that this issue deserves?
The answer to that question is I think that the depth of scrutiny that this issue deserves has been addressed in Lord Carlaway's report and the consideration that has thereafter taken place. I think that the process of parliamentary scrutiny will clearly enhance that, and we're delighted to be involved in one of many parties providing evidence, as we do for many bills. But no, I don't think that there would be any enhancement to the position as we understand it, and there wouldn't be any change to the Police Scotland view should we delay the proposal as it currently stands.
Oh, thank you. It lays all my worst fears about a single police force. Mr Connor.
Mr Connor, yes.
Thanks very much. Yeah, just in terms of the point you make, I mean, in terms of deferringness and looking at other ways to scrutinise the bill, I think that is a matter for the committee, but whether you defer it now and implement it a year or not, I keep coming back to where I started. In terms of the way the police go about their business, the way the police gather evidence, the way the police report the facts and circumstances, nothing will change. We'll continue to conduct thorough, professional investigations and report the facts and circumstances to the Crown.
Question, Mr Connor, it's whether you think there would be merit in fully discussing this and having it looked inside out to make sure we get it right for your police officers,
yes,
for the ordinary man in the street going into the courts. Would there be some merit in putting it to a Royal Commission so that every aspect is looked at thoroughly by those in the best position from all walks of life to contribute to that debate?
Well, I believe this is very much part of the scrutiny. You know, the scrutiny has been applied by this committee today, raising the very important issues that have been raised today as part of that scrutiny. And, you know, to take it forward to a fuller Royal Commission, by all means, there may be merit in that. There may be merit in bringing other professional, other views into the equation to have that discussion. But that is a matter for others, and I certainly believe that, you know, the level of scrutiny that has been applied just now should hopefully inform the debate from a police perspective.
But you wouldn't rule out a Royal Commission looking at it?
That's very much a matter for others.
Mr Ross?
Well, I think we'd probably take a similar view to our colleagues in ASPA. If you asked me, was our current position the unanimous view of the Scottish Police Federation, and the answer to that is no. It's our view on balance now that we would support the general requirement for corroboration being removed. I don't think, irrespective of whether we have a Royal Commission or not, we'll ever get to a position that that will be the unanimous view of the Scottish Police Federation, nor indeed the whole service. there are a wide variety of views, not just in the police service, but across the whole criminal justice system about whether this is the right thing to do or the wrong thing to do. And a lot of people sitting somewhere in the middle of that debate. Whether a Royal Commission would bring more clarity and afford people more opportunity to make up their minds in relation to how they would potentially support or otherwise this, I genuinely don't know. I tend to think that the more information that people are provided with, the more scrutiny that's applied to this, the better. And because it's important that whatever we do, we get this right, and that the criminal justice system is not damaged by progressing this bill. I take the same view as David in terms of what we would do as a service. We'll do the same as we're doing now, irrespective of whether this bill is passed as is or not.
Could I pin you down, please, Mr. Graham? You say, or the Police Scotland say in its submission, that corroboration of all material facts will always present a significant challenge. What do you understand is required just now as the very basics of corroboration in the criminal justice system?
Well, as the committee's heard and as Lord Carloway explained in his report, the current law in relation to corroboration in different cases is extremely complex. That's one of the issues that's under examination here. That complexity is based around about the legal developments over the years, from the starting position where I think Lord Carloway brought it back to some principles from the Old Testament, to a position where, and it's been described by some commentators as the corroboration fiddles have been twisted and adapted to fit in with the developments in society, legal process, evidential availability, and the original concept in a very simple terms has perhaps been overtaken by all of those changes and developments. So I think to answer the question, if it is what do you understand by the current law under corroboration, then there's a very complex set of case law that lies underneath that, which would take some time to go into.
Well, given this complexity, then you don't think there's a case for it being taken out to Royal Commission. Will I tell you what the basic requirement is? It's really quite simple. Do essential facts require to be established? Did an offence occur? Did the accused do it? And both of these essential facts require to be corroborated. Nothing else. That wasn't too difficult. Shouldn't be too difficult, should it, Mr. Gray?
I think I'd like to keep the tone. I know everybody's very passionate about this, but if we could just keep the tone polite, please.
I will keep the tone with great difficulty.
Yes, I know, but you manage it. She's
because we're looking at this tenet of Scots law, which has been passed down by the institutional writers, which has been flexible and which has not only provided justice for victims, but crucially has protected the rights of the accused. Because once imprisonment is imposed on someone unjustly, you can never get that back, which is why the standard of proof is beyond a reasonable doubt. So I ask you again, given the complexity you've talked about, isn't there a case to take this out? Has the view and the evidence you've heard today not changed your mind in the very slightest?
Well, I'll go back to where you started in terms of describing the essential facts and the current legal position that they require to be corroborated. I think I'd already covered that in my evidence, that very clearly understand that position. I had thought that your question was, what does corroboration...
Mr. Graham, you did actually say there has been a crime and there has been identification. I think you did some words to that effect. So I think in fairness, but I appreciate that it's people are very concerned about this. Could I
perhaps finish my answer?
The comments about all material facts need to be corroborated way down the line, which simply isn't the case.
I think what I was trying to provide in my answer was some exploration of the depth of concern there is about the complexity of what corroboration actually means in the huge variety of different cases. So whilst the test at a high level is simple, the interpretation of what corroboration actually means in different cases has been twisted and has developed through time to
I
the
think
point...
you prefer the word has evolved rather than twisted.
Well,
you may not want to use the word twisted.
I accept that, but certainly there is a perception that evolution has perhaps gone to a point where the original concept now needs to be revised in the way that's being proposed. And no, I'm not, I think in answer to your final question, which was, are you not now convinced, based on what I've heard today, that further examination, in whatever terms that would be, needs to be undertaken? Now, I'm not convinced of that at all, for the reasons that I've outlaid, which I won't repeat, noting the convener's comments from earlier. But I think that there needs to be a clear focus on what the justice system is there to achieve. I think that the current law round about corroboration is unclear to people. I think this would provide a clarification, a simplification, and I think it's very clear that there's a long history of the law evolving and developing to take account of other changes in society, public values, etc. And it's absolutely appropriate that the proposal that's currently in the legislation is taken forward now.
Different point, yes.
Different point. And this is to Mr. Ross and Mr. O'Connor. Following on from what John Finney has asked about the professional witnesses being susceptible to malicious allegations, the Lord Advocate has given some assurances, some guidance almost, that proceedings in such cases would not be taken out without strong supporting evidence. Does it give you any cause for concern that the Lord Advocate may change and a new Lord Advocate may have a different view?
As a staff association that represent the vast majority of police officers, the proposal in itself initially gave us quite significant concern, in the sense that our members frequently find themselves in positions where they themselves are uncorroborated. They're on their own attending an incident, and there may be several others who they're dealing with who may or could potentially make some sort of spurious allegation against them, corroborated by each other. Now, that's always been the case, and to date, that hasn't resulted in a vast number of police officers being prosecuted as a consequence of these kind of allegations. I think that the evolution of CCTV, mobile phones, etc., and indeed our own, in some areas, cameras on police officers, etc., has provided a degree of protection to prevent that, and indeed what the Lord Advocate has said in relation to measures that he would put in place regarding other evidence to support any of these kind of allegations has indeed provided some reassurance. But I can tell you now, I mean, in terms of allegations of false accusations of crime against police officers and allegations of wasting police time, I am personally aware of significant numbers of those which haven't been proceeded, individuals who haven't been proceeded against on the basis that it wouldn't be in the public interest to do so. And certainly when I was a Joint Branch Board Secretary in the former Northern Force, I had a drawer full of letters from the Procurator Fiscal in Inverness telling me precisely that. Whilst there might be a sufficiency of evidence to prosecute an individual, it wasn't in the public interest to do so.
Yeah, I think it's a very fair point. It's a valid point. We have raised concerns, and I think, over the years we've seen the false allegations that have come forward. We've seen acts of what we would consider to be public mischief. I think it has been an issue of concern in the past, and the Lord Advocate has given a reassurance. But I would have to say, and I hope David would agree with me, there will still be some concerns amongst our members. Potentially be an issue.
Thank you for that.
No, Graham, yes, you see.
Yeah, I think it's important to stress, and it was already hinted at, apologies if I didn't pick it up properly, that I don't think anyone would be seeking that there should be a different standard in terms of investigation or legal process that would be applied to people in different positions in society or different professions. I think something we can agree on is round about the point that was made of the burden of proof, which will remain as it is just now, and that the sufficiency of evidence that will need to be gathered for that burden of proof to be met will be changed slightly in relation to the quantitative assessment of the evidence that's put forward, the assessment of the quality of the evidence is absolutely key in relation to the final outcome in court and that sufficiency test being met. I think that's very important to emphasise that.
I'm going to move on, forgive me. Sandra, followed by Elaine. Sandra.
Thank you very much, Convener, and good morning, gentlemen. Can I just put on record my thanks to Police Scotland for the work that they've done in the recent tragedy at the Clutha Vaults in Glasgow. I just want to put that on.
I'll say that on behalf of the entire committee, and we appreciate how involved not just Chief Constable has been, but also Fire and Rescue Service and Ambulance as well.
Thank you. Thank you very much, Convener. I just want to go over some of the issues that's been raised, more for clarity than anything else. And yes, the Convener is quite correct. We've been looking at this in the corroboration issues for quite some time, and we all know about corroboration. But I think for the general public and obviously the press out there as well, could you just, well, whatever your thoughts are on it, would you confirm that it's vitally important for us, you know, basically to remember that it's the legal and technical aspects of corroboration which we are seeking to remove, or proposing to remove, and not corroboration per se? I just want...
Establish that bit.
No, Convener, it's for, I mean, speaking to the general public, as we all do, and the press, I think it's really necessary that we get this on record, that is a part of the legal.
I think I put it, in fairness, Sandra, I think I put it on the record very clearly when Christian Allard asked his questions, that we knew exactly what it meant. And
Chair, I'm not disagreeing with you. I just would like it for the sake of the public and the press. That's the legal and technical requirement, which we're proposing, and not the abolition of the whole thing. Also, can I just say that in Scotland, corroborate has become a very narrow technical meaning, and I think it was Chalmers and Lerwick, Professors Chalmers and Lerwick, in the recent article said the Scottish law of corroboration has become technical and highly complex and cannot simply be described as a two-witness rule, basically. Now, you mentioned that yourself, Mr Graham, and obviously David and David Ross as well. Could you perhaps elaborate on that particular one? You've mentioned the fact about the evidence, and this is technical, and I'm talking about, you're talking about rape victims. I'm also talking about perhaps older people who are in a nursing home, or children who are in care homes who don't have a other witness there. So could you perhaps elaborate on what evidence you would be perhaps looking for, and would evidence of distress be enough to be collaborative evidence in that?
Well, I'm grateful for the opportunity for clarification, and I think we have already discussed that we're talking about the absolute requirement for corroboration being removed. But there is an important point that in the public consciousness, it's impossible to explain the nuances and the technical complexity, which even in the length of time the committee has to examine this, I wouldn't be able to articulate with any sense of depth, given that the case law in different cases, different adminicals of evidence, and where the standard of corroboration would be met is highly complex and has developed to such an extent that it's difficult, I think, even for those who are practising in law and indeed High Court judges to interpret, as we have heard, in a consistent way. In relation to the examples that you raise, I think I've said already that one of our key concerns is that the law as it currently stands is potentially discriminatory against particular vulnerable groups of people. I have one case, which was one of the cases that we examined, which involves potentially what we would call bogus or fraudulent workmen with an elderly victim, an elderly woman who was in her home when she was approached by some people looking to do roofing work. They offered to do the work for £500. She thought that her roof did need some maintenance, and she gave them the money from her purse. They went away for a short time, came back later to say that they then needed £300 for materials. She went and gave them the money for that as well. They said that they were going to go to a builder's yard to get some materials and never turned up back at the house again. That was reported to the police with detailed descriptions of the men and the registration number of the van. The two males who were in the van were stopped a short time later, and they were wearing clothes that were similar. In addition, the ladders on the roof of the van matched the description that had been given, and a quantity of some business cards that were similar to a business card that had been given to her was found. Now, in all the circumstances, there was a high quality of evidence, but the essential facts of that case, it was deemed, did not pass the test of sufficiency for each of the essential facts to be corroborated. And it's a very good example of where, if we were to look at the overall quality of evidence, then it's the type of case that at the moment might not hit the bar, and this actual case didn't. And in the future, there will be an increased prospect that cases like that will. Now, I need to be clear, that's not to say that in all cases we're going to be able to resolve circumstances like this through the justice system, and of course the police part in that is just one. But I think it's illustrative of the point that I'm trying to get across, that there's a technical barrier which does not assess the quality, the overall quality of the evidence, and therefore allow that to be presented to a court and to a jury in the system that quite rightly we hold as the justice system in Scotland.
Yeah. Again, it's in terms of corroboration, it is very technical, it is very complex, and I have to say, over the years as a commander and senior investigating officer, we have reported many cases to the Crown where we believed there was corroboration, and a lot of these cases, for one reason or another, haven't actually been proceeded with. And I think it's when you get into that level of debate and discussion, you know, we've clearly believed there has been corroboration, and the Crown has taken a different view, and that for me just has highlighted the complexity of the subject at times.
I've nothing really to add other than to say that the police's role in this is to gather the evidence and report that to the Crown and Procurator Fiscal Service. It's a matter for the Crown and the courts to determine whether that's a sufficiency of evidence, or indeed whether they believe the evidence that's been presented.
Chair, can I just raise one more? Thank you, Chair. Is it not a fact that the International Criminal Court of Justice does not ask for corroborated evidence in the technical terms?
Less qualified to make detailed comment on international law or jurisprudence, no doubt, than many other individuals who may appear before the committee. But as I referred to earlier, without trying to articulate international law, it's my understanding that there is fairly widespread reporting that the technical barrier, as it is now deemed, of corroboration in Scotland is seen as being potentially discriminatory when compared with other international legal systems.
Okay, could I just to clarify that point, and I may give you a quote from the International Criminal Court. It says, "A chamber shall not impose a legal requirement that corroboration is required in order to prove any crime within the jurisdiction of the court, and in particular crimes of sexual violence." So International Criminal Court does not require the legal requirements. And I say once again, maybe we're getting fed up with it, but we need to remember it's the legal and technical requirements of corroboration in that aspect. Could I ask about the test for prosecution, or will I come back on that one?
I don't know whether that's relevant to this panel, because I fully appreciate we're looking at, and quite rightly, from police and absolutely within that box. It's absolutely right. So I don't know if that, you can answer if you like, but I don't know if you feel that's something that you want to wander into.
Yeah, no, I think I would agree that I wouldn't wish to speak clearly on behalf of Crown Office, Procurator Fiscal Service or the Lord Advocate. I mean, I would add, however, that we will be working with them in developing these proposals to ensure that guidance from the Crown to the police remains appropriate. And I think the Lord Advocate's outlined some of the measures that would be put in place to ensure that there was a clear understanding, and in fact, to echo what's already been said, that in essence means there will be no change to the standard of police investigation. That's a very important point to make.
I think you know, I don't think we're really challenging that sitting here in the main. So can I just move on to, thank you. Right, it's Elaine, followed by Roderick, followed by Alison. I'm conscious of time and I'm not shortening questions, but we've had a good bite at this and we've got quite a lot resolved, I think, or perhaps not. Elaine.
Yes, first question really is for ASPS and the Scottish Police Federation, because you are organisations which represent police officers of particular ranks. I'm correct in that assumption, am I? I just wondered, in terms of the change in position on this, on corroboration, whether that had been discussed with your membership.
Yeah, indeed it has. We consult our members through our Joint Central Committee in respect of almost all decisions that we make, and ultimately our position is determined by our Joint Central Committee, which is representative of the whole of the country. Has every police officer in Scotland who's a member of the Scottish Police Federation had the opportunity to make comment on this? Absolutely. Have they all chosen to? No. Is this a unanimous view of the Scottish Police Federation? No. Indeed, the previous position we had wasn't the unanimous position of the Scottish Police Federation. It was on balance our view. On balance, this is our view now, based on how the debate and our understanding has developed.
Yeah. So what do you think changed the view of your membership on this?
I think probably a better understanding of what we were talking about. I think the fear initially when people talk about the blanket abolition, the wholesale abolition of corroboration, was that corroboration in all its forms would no longer exist. And I absolutely understand that wasn't the intention, and there was an understanding amongst those who sit probably at the helm of the Scottish Police Federation. That was our understanding too, but it wasn't necessarily our members' understanding as this debate came out. And broadly because a number of them had read Lord Carloway's report, and that's not what it said. It seemed to indicate that corroboration in this criminal justice system would just be eradicated completely.
Because, I mean, obviously what is under discussion at the moment is not Lord Carloway's report, it's actually the legislation. And the legislation says that if satisfied that the fact has been established by evidence in the proceedings, the judge, or as the case may be, the jury is entitled to find the fact proved by the evidence, although the evidence is not corroborated. I mean, that's what the legislation actually says. It doesn't actually talk about different strands. It says that, you know, it can be proved if it's not corroborated. And that has always been the position in terms of the legislation. It hasn't changed.
Yeah, the word corroboration, I think, is probably a misnomer in terms of all of this, because what we're talking about is a sufficiency of evidence to prove beyond a reasonable doubt that somebody committed an offence.
We know this. We know about the burden of proof and the standard of proof. So we've always understood this. I think that's what you're driving at.
Can I just go on then to ask, I mean, I appreciate that the police are often frustrated by presenting a case to the Procurator Fiscal than the case not being taken. And that has been said to me over the years by police officers. That's an extremely frustrating experience for the police, having done the investigation, for it not to be taken forward. But there was you made it, I think it was Mr Graham made a case around the 3,000 additional victims who would be able to have their cases taken to court. The problem,
to the Crown.
So to the Crown, yes, and then the Crown would decide whether or not they took them to court. The evidence from England is that the conviction rates for things like sexual offences and domestic abuse is actually no higher in England than it is in Scotland. So are we not just talking about the ability to go to court to be disbelieved rather than be told that you can't be taken to court in the first place? I mean, is it actually going to mean greater justice for victims, or is it just that you get further down the process before your case is kicked out?
I'd be happy to address that. I think you know, the eventual outcome of what happens through the whole justice process, an outcome to a court case, is very difficult for the police to predict and make comment on. The example of comparing with England and Wales perhaps isn't making a straight comparison, because there are a large number of differences in terms of legal procedure and indeed criminal law, which might have an impact beyond just the changes that are being proposed in this bill. And indeed, my understanding is that the conviction rates for certain crime types, some of the ones which I've been covering, are higher in England and Wales than they are in Scotland at the moment. The other thing that's happening is that there are a lot of fairly significant changes in the way that some of these crimes, and you mentioned serious sexual crime, the way in which these are being approached. So since Police Scotland's been created, we've changed fairly dramatically our approach to investigating and working with victims and victim support agencies round about serious sexual crime. We're working very closely with the Crown Office Procurator Fiscal Service to ensure that we're all going to be working very closely together to take advantage of any opportunities where there's quality evidence at the moment, and therefore it will be very hard to determine if this law is changed, what impact that will have alongside all the other changes that are currently going on. And I already mentioned the increase in reporting to the police of serious sexual crime, which is an extremely positive development, is in part down to proactivity of the police in terms of tackling domestic abuse and working with victims groups, and overlaying that in terms of some of the measurement and assessment of this will make it very complex to unpick and understand what has had the impact on the eventual outcomes. I think what is important is that we're doing everything that we can to demonstrate that such serious crime and support and outcomes for justice are extremely important for the victims. And I think when you say that the police are frustrated at times when a case is not taken forward, I think we do that organisationally out of a sense of frustration for the mission that we're here for, keeping people safe and acting in the interests of the victims of crime who've come forward, and have an expectation that we'll do everything we can to meet their expectations.
Mr Ross made reference to checks and balances, and of course one of those prosecutorial tests, which I think we've already discussed. The other two were the ability of the judge to dismiss a case, and the jury, the change in the jury majority, which obviously would not affect, and we were told, I think it was something like 96% of cases or summary cases, so that's not going to be a check or balance for those. Do you think those checks and balances are sufficient?
I think that's probably the element that we're more persuaded of now than we were when we initially responded to this bill, that the checks and balances across the whole of the case, not just by the Crown but by the court, are sufficient that whatever evidence is presented will still need to meet the burden of proof.
But there was never actually any intention of changing the burden of proof, was it?
No, I don't think there was. I think there was a widespread perception that there was, but I agree.
I'm flabbergasted that that was ever in anybody within the system, the criminal justice system, from police onwards and upwards, right up to the High Court, ever thought that we're ever looking at touching the burden of proof or the standard of proof.
That's not what I said. I think what I'm talking about is the corroboration, and I think
well,
if we had talked about a sufficiency of evidence rather than the word corroboration and explained it in those terms, then I think it would have been far easier for everyone to understand what the intention here was.
I'm just going to move on. We've got time. Roderick, Alison and John Pentland. Roderick.
Yeah, Mr Graham, just if I can just start by an ANARAC point, I'm afraid. We heard from the Crown Office on the 20th November about the exercise in terms of the number of cases that might be referred by the police to them. And their evidence was that there'd been an increase in the number of reports was about 1.5%, which equates to another 3,720 cases being reported. I mean, you may have been just talking in global figures, but would you agree with those Crown Office figures, or do you want to write to us to confirm when the slight difference is?
I could write to you with a greater level of detail. The exercise, we've done two exercises. The Crown did a separate exercise which came out with broadly similar figures, but they were slightly different. They were using different case samples, and there was a distinction in at least one of the exercises between solemn procedure and summary procedure. I'd be happy to write with the details of all of the figures, but broadly speaking, the overall figure was a 2% increase in cases, and that was where, broadly speaking, the 3,000 victims came from, which I'd be happy to clarify in writing.
I'm happy to leave that one there. Just taking it back to Lord Carloway's report, Lord Carloway didn't recommend any safeguards were necessary if the requirement for corroboration were abolished, on the basis that, in his view, the principal safeguard was the requirement to prove a case beyond reasonable doubt. I'm now actually quite confused as to what, in fact, particularly the Scottish Police Federation, think that are the appropriate safeguards in the system which have emerged, which they weren't aware of before. So can you just clarify for me what safeguards you believe would be necessary if the requirement of corroboration is removed?
I think, in truth, as I've already explained, it was one of perception rather than reality in terms of our understanding of what was meant by this initially in Lord Carloway's report. And as I've already articulated, it's always been our position that we would gather and report as much evidence as was available, and it would be back for the court to determine whether that was a sufficiency of evidence to prove beyond a reasonable doubt or not, whether somebody was guilty or not. I don't think our position has changed. Our understanding has changed in terms of what we are talking about here. And if we are talking about corroboration being achieved across the whole of the evidence, as I've said, then I think we are sufficiently persuaded that that will still continue. You know, we talked about checks and balances, the whole of the evidence, special measures and all these kind of things. All of these things taken together for me still mean corroboration. And that, I suppose, was in terms of perception, was not our initial understanding, that there was a perception amongst us, rightly or wrongly, that the evidence from one single source could potentially provide sufficient proof to take a case to court and to convict somebody. And that, for us, was a step too far.
In your written submission, you refer to the link between corroboration and low conviction rates as needing further detailed research. I'm assuming now you don't want to carry out further detailed research, but you also, secondly, go on to say that you believe the majority verdict of the juries would need to be reconsidered. Are either of those points relevant to you now? Or?
I think the research, in terms of the research, I think that's already been done to some extent by Police Scotland. Whether it would benefit from more research, I generally couldn't comment. I'm obviously content to accept the figures that have been put forward by Mr Graham. I'm sure they're accurate. In terms of the majority view, the majority verdict, I don't think that's a matter for us to form a view on. It's a matter for those in the legal profession.
And finally, I'm conscious of the time. Just want to say, we talked earlier a bit about penetration. Presumably you would accept if the only evidence in the absence of corroboration is the complainer's evidence that there has been penetration, although the case might then be sufficient to pass to the Crown Office, that might present difficulties for the Crown Office in deciding whether to take the case further.
Yeah, I think if we're speaking about rape and serious sexual crime, the complexities of not only the essential facts that need to be proved for the different offences that now exist under more recent statutes, but also the circumstances in which corroboration would currently be considered would take some time to work through. In relation to the specific point that you make, I think the easiest way to address that is that the Lord Advocate's been very clear that they wouldn't expect a case to be received where it is solely the testimony of one witness with no other supporting evidence. Now, in the example you give, it's highly unlikely that that would be the case for a serious sexual crime, but not impossible. And therefore, I would reiterate what I've already said, that we'll continue to do everything that we currently do to thoroughly and professionally investigate all these crimes and report the matters to the Crown. In the cases of serious crime, I think the point was made at the start by Mr Finney, it's more likely that we would report to the Crown where there was a higher level of doubt on our part that there might be a sufficiency, and therefore, quite understandably, these cases do come under more scrutiny in terms of whether the evidential sufficiency test is met.
Thank you.
Alison.
What a very strange morning. We've been told repeatedly that we're removing corroboration, but we're not removing corroboration. There's a lot of news speak going on here, and it really concerns me immensely. Let's be very clear. The bill removes the need for corroboration, and there's no point in trying to fudge that, but which is what I think has been going on this morning. And I'm really rather disturbed by that. There's been a great deal of focus on the victims, quite rightly so, that you've said might well have access to justice, and Elaine Murray has pointed out that access to justice might not well be well served if the requirement produces more prosecutions but not any more convictions. But we've heard a lot of evidence in this committee that the removal of corroboration will mean that we will see the likelihood of many more miscarriages of justice, and I would like the panel's view on whether or not we should pay no heed to that evidence.
Well, I don't think you should pay no heed to it, clearly. Everybody that comes before you presents a valid view for assessment, and it wouldn't be for me to say otherwise. I'm not sure on what basis those views have been expressed, and in monitoring some of the positions that people have held, I haven't seen terribly much evidence to support the position that there would be more miscarriages of justice, and I would represent the current position in relation to the points that I've already outlined, and noting a previous caution in relation to repetition.
Of miscarriages of justice. Birmingham 6, I think it was, were there not quite a few there?
Well, I'm
trying to recall.
What I reported back, convener, was that I wasn't clear that people who had presented the position in Scotland...
Criminal Cases Review Commission gave us that evidence.
Right.
Member from the Criminal Cases Review Commission.
So it's not clear to me what the link is between these cases and whether there was corroboration or otherwise. And I mean that genuinely. It's not clear because that's not something that I've examined. In relation to Scotland, then I don't think there is any credible evidence to suggest that there would be more miscarriages of justice. And what I was going to say, without repeating myself previously, I think at the moment we have a travesty of justice where there are so many people who are not given access to what they would expect because of the technical barriers which remain in place.
So you're not concerned at all about protecting the right of the accused?
I would be very concerned if I thought that there was an enhanced chance that there would be miscarriages of justice as a result of what's being proposed. I don't have any evidence, and I don't believe that there is an enhanced chance that there will be miscarriages of justice as a result of what is being proposed. I think it's very clear, as we've already said, that the burden of proof, the test of sufficiency put before the court, and all of the other measures that are in place to do a qualitative assessment of the evidence in terms of admissibility, etc., are in place.
Those measures are not in place. They will not be in place when this legislation is put through.
Well, I disagree with that.
Can I ask you, you made an interesting part. You said it wouldn't give the victims what they expect. And I think what we would like to know is, let's say a victim of rape or sexual abuse and domestic violence just now, with this change in the legislation, what's your understanding if this legislation goes through and, you know, we don't require to have mandatory corroboration? And I appreciate the difficulties of the police and that you're meeting these people, and it's, the difficulties and so on for you when you can't take them to the Crown Office. What do you think the victims will expect if this change comes through? What's your thoughts on that?
Yeah, I deliberately use the term which I accept lacks clarity or definition, because what victims expect is different in different cases. And actually, I think the point was made earlier that it might not produce better outcomes if a result of the change in law here merely meant that victims' cases were taken to court, but there wasn't an increase in prosecutions, for instance. That's not necessarily the case with all victims. You might find that for some victims to have had the opportunity for there to be a court case, even if the outcome doesn't result in a conviction, is a far better place for them to be in than for there not to have been a court case at all. Now, I can't generalise, because my experience, my long experience in dealing with victims of serious crime, is that their expectations in coming forward to report it to the police are very, very broad and different.
just if you could expand, because I think this is getting to the nub of what concerns us, is that what particularly in these very difficult cases, that what the expectations of the victims would be. Would it simply be that the police then take it to the Crown? The Crown may then decide it's, you know, there isn't sufficiency of evidence for it to go to court, and that might be, I think our concern was that would be very damaging to victims, or indeed that the Crown then felt we've got to take it to court anyway, and then they have a hellish time in court to find out that they're perhaps not believed. So I think that's what's part of the thing that's at the background to this. So you say everybody has different expectations. So for some people, it's just sufficient that it's reported to the Crown Office. End of story.
Well, for some victims of serious crime, it's sufficient that it's reported to the police, because their intention coming forward is that we can... Well, I appreciate that, but then it's got to go from you to somewhere else. So, you know, having done that, reported it to you, sometimes now are you not taking it to the Crown Office because you say, well, we haven't got sufficient to take it to the Crown Office? That will be the case in some cases at the moment, and even if this law were to be passed, that would still be the case in some cases in the future, the point that I've already addressed. I think the point I'm trying to make is that the expectations of people who have been victims of serious crimes varies, and it's not for me to try and generalise that all victims would have an expectation that the best outcome would be a successful prosecution. Clearly that is the expectation of a large number of victims who come forward, and the proposals, and I'm very clear in terms of what the proposals are, from the assessments and the exercises that we've done, would be likely to increase the number of victims who would see a successful prosecution in their case.
Follow-up question for Mr. Ross. When you were speaking at the beginning and explaining your shifting position, did you say, I maybe picked you up wrong, that when you met the Lord Advocate?
No, from comments made by the Lord Advocate.
Comments made by the Lord Advocate, that's fine, thank you.
John.
Thank you, Convener. Mr Graham, on behalf of Police Scotland, you have welcomed a proposal to abolish the requirement for corroboration, and, you know, unlike some, you've outlined the reasons why. However, this proposal comes at a time when Police Scotland are going to be facing significant financial pressures. Is there any connection? You know, is there any connection that perhaps that, you know, your support has been driven, has been financially driven?
I agree that it does come at a time where there are substantial financial pressures on Police Scotland, and indeed the wider public finances, as has been well reported through the parliamentary committee structure. It is absolutely not the case that our support for the proposed changes to the law around corroboration would be driven in any sense by financial pressures, and indeed the financial memorandum that accompanies the bill, members may be aware, actually demonstrates that our assessment was there would be a slight increase in costs associated with the changes that are being proposed, because we would anticipate that we would have to report a higher level, a slightly higher level, as I've already said, of cases to the Crown, and then we would have to support for longer and a slightly higher level of solemn cases, which would require a greater capacity in our IT systems and a greater capacity in terms of resource. So it's not a substantial cost increase, but just to make it clear, what's being proposed here, our assessment is that it would actually cost us a little bit more money to do. There aren't any cost savings associated with the law change as it's being proposed.
Only one final one, because it's something we haven't touched on, and that is to do with the Section 14 release on conditions investigative liberation. And where, and that's that expression again, person not officially accused has been released within that 28-day period, has not expired. To give the opportunity to put on the record, it might be seen as this being, you know, to help the police when they don't have any corroboration, and accordingly they've already got somebody personally not officially accused, but they're releasing them on conditions so that they can then go and find the evidence that they should perhaps have had in the first place before. I'm not saying this is your position, but that might have had in the first place before they were taken in as not officially accused.
I think if I may...
How do these interact?
Well, I think if I may, convener, to sort of challenge the phrase that we perhaps should have had in the first place as a wild assumption.
It's not my position. I'm saying that might be put to you. It's,
right.
It's a proposition.
Right, okay. Well, is there a link between the proposed change in corroboration and the investigative liberation proposals in the bill? Is that the question?
Yes, that's the question.
Right, well, no, I don't think there is. I don't think there is a link between the two, because I think that the position round about corroboration that we've taken relates to all the circumstances of all the cases that we deal with, and that the continuum means that we have long-running investigations where, for very good reasons, we're trying to gather evidence about what we know a crime's been occurred. We haven't identified who's done it. It might be a serious crime or less serious. We might not identify who the person is or get what we feel is a sufficiency of evidence to report that to the Crown for many weeks or many months. It wouldn't fit necessarily within the requirements of the investigative liberation section, and back to a position where we arrest somebody in the commission of a crime and there's sufficient evidence at that point. So the position round about the proposed change for corroboration is one out of principle, and the proposals that we've supported round about investigative liberation are out of practicality.
Because the test is reasonable grounds for suspecting that the person has committed an offence. It's yes. Quite a light, some might say that's quite a light test. Reasonable grounds for suspecting.
That's the current test for somebody being detained at the moment, and has been since 1980.
There's no change here.
No, in terms of investigative liberation, I take on board the point that's been made about finding evidence against the accused, but the investigation should draw in all evidence, and some of that evidence may actually clear the accused. So, you know, it's got to be very balanced, and that's what that time needs to be used for.
You don't need to, Mr. Ross, to add. It was simply to put it to you as part of the test of the legislation. Can I thank you very much for your evidence session, which has been far longer than anticipated, for reasons I think I understand. And I'm going to suspend, and if you're happy, I'll suspend for 5 minutes, give you a little break. You look happy about it. Suspend till, yes, for 5 minutes. Thank you very much. Thank you very much. Back in the saddle, and can I welcome to the meeting Sheila McCall, Commissioner of the Scottish Human Rights Commission. Yes, there you are, our Human Rights Commission. Tony Kelly, Chair of Justice Scotland. Alan McCloskey, Acting Deputy Chief Constable, Victim Support Scotland. Acting Deputy Chief Constable? No. I did not write this script. What would you like to be?
Deputy Chief Executive.
Deputy Chief Executive, that's what you will be. Deputy Chief Executive. Today, Mr McCloskey, you're Deputy Chief Executive. That's it. And Sandy Barton, Helpline Manager, National Coordinator, Rape Crisis Scotland. And Lily Greenham, Manager, Scottish Women's Aid. Welcome to you. And I'm sorry you've had such a wait, but you would appreciate, we really want to dig into this, the evidence, and we will be the same with you. And can I thank you all for your written submissions. I'm going to invite questions from members, but some have been here before, some haven't. If you wish to, unless there are questions directed at you straight away, is to just let me know and I'll call you, all right? And your microphone will come on automatically, as mine has, even when I'm saying indiscreet things. So I've got to watch what I'm saying. Alison.
Members' attention to my register of interests and the fact that I'm a member of the Council of Justice Scotland. Thank you.
You don't want to ask a question. You could get in first if you wanted to.
No, quick. It's okay. It's okay. Well, yes, okay. As soon as I've got in first, I will do that. Clearly, we're focusing entirely on corroboration at the moment, and I would be interested in the panel's view. We've heard a lot this morning about access to justice, whether access to justice is served if removing the requirement for corroboration results in more prosecutions, even if it doesn't necessarily lead to more convictions.
Mr. Kelly.
I can start with that. I think that certainly would be the case, that access to justice would be facilitated by the removal of corroboration. The problem is that that's a skewed view of things. There's clearly a much greater things at work than increasing access to justice on the part of victims and complainers of crime. And the problem is that, as Lord Carley correctly identified, corroboration is really at the foundation of every aspect of the criminal justice system. So the removal of the requirement of corroboration would operate at the stage of reporting of crime to the police, the stage of the police reporting to the Fiscal's office, the stage of taking the matter to court, and that's where I think access to justice is being invoked, the matter of taking the matter to court. But also corroboration acts in the course of the trial at present, and that would be removed as a safeguard. And most importantly, it would be removed from the power of the judge to rule upon the question of the evidence that's been led, and that would be wholly removed if the provisions before the Parliament are brought into force.
Does anybody else wish to come in at this stage? Yes, Ms Barton.
I think it is really a very important issue in terms of access to justice, and it's spoken here as almost in an almost derogatory way. I think it is about improving particularly in cases of sexual violence and domestic abuse, where there are real difficulties in gathering corroborative evidence. And I noticed in the last discussion there was some highlighting of the confusion around corroboration, that it isn't about removing corroboration, but it is about removing the quite high and technical bar that every element of the case needs to have corroborative evidence. It isn't saying that the police won't be looking for supporting evidence that backs up a report. So I think that's really crucial to make. But I think it is about improving access to justice, whether that's about reporting to the police, whether that's also about then the number of cases that proceed to prosecution, and also about putting, I think the Lord Advocate's examples give really compelling examples where there is a high level of supporting evidence that I think for most people they would look at that and think that that corroborates the report that's been given. So I think that is about giving cases such as those access to court in a way that they don't have at the moment.
Oh, well, let me clarify. I mean, I don't think anyone's spoken in derogatory terms about access to justice or indeed the issues that you particularly relate to. But there has been some suggestion in earlier evidence sessions that there is somehow a right for people to have their day in court, as if that in itself was important. And I think I'd be interested to hear the other panel members' views on that.
Yes.
Perhaps I could add to that. From our perspective, I mean, access to justice is a very wide-ranging view, but it starts with the victim, and the victim being believed in the very first instance that something's happened and they need access to information, access to support, and justice to be done. In its simplest terms, they want justice to be done. And they want the police to help them, they want the Crown to help them, to get their access to justice. So it's yes, there's rights and absolute rights for the accused, but the victims and the witnesses also have rights, and that forms part of it. So it's a very simple concept, is the way that I would take it.
Does anybody else wish to come in on that? You can comment on as well. Ms McCall.
I'll maybe zoom out slightly and say, from the perspective of human rights, what the Parliament has to do with this legislation is ensure that the system does two things. One is it provides a right to an effective investigation and prosecution where appropriate for victims of serious crime, rape and domestic violence and so on would come into that category undoubtedly. At the same time, the system has to ensure that when an accused is brought into the investigation and prosecution system, that he receives a fair trial, he or she receives a fair trial. Now, Mr Kelly is right, I think, to say that the effect of corroboration plays differently in both those respects. So I would agree with him that if you remove the requirement for corroboration as a legal requirement, more cases potentially will get to court. I pause for a note of caution about just how many more, because I was listening to the evidence of the Lord Advocate and the Head of Policy from the Crown Office. And as I understood Ms Dalrymple's evidence, you'll have a better recollection than me, of I think the 2,803 domestic incidents that were reported to the police. When they reviewed those in terms of how many would proceed to court, I think she said it would be 1,000. So it's not that there will be an open door and everything will get through. The prosecution test will have some impact on that. But no doubt there will be an increased opportunity to get to court. But once you're in the court, access to justice for an accused person includes proper means by which to challenge the quality of evidence against him. Corroboration serves that function now as a means of quality control. If you abolish it, as our system currently stands, without reassessing it and seeing what other safeguards might be needed, there is nothing there apart from the ability to cross-examine that provides that proper means to challenge reliability of evidence. And there are some areas of evidence which the European Court recognises are inherently problematic: doc identification, hearsay evidence, these sorts of things. So I think we have to keep in mind both perspectives when we talk about access to justice.
I'd like to add something to that in relation to evidence, and that is to be clear that when we're talking about crimes of violence against women, whether it's sexual violence or domestic abuse, and with respect, Sheila, domestic abuse is not dealt with as a serious crime on the whole, it's dealt with as a summary level, so but corroboration is still required in order to get it there. We're not usually talking about evidence as being the driving force for whether or not there's a conviction. We're talking about attitudes, we're talking about assumptions, and we're talking about prejudice. So the notion that removing the requirement for corroboration is in any way going to change that situation is a false notion. What removing the requirement for corroboration will do, and I speak, in this case really from the perspective of someone who represents the interests of a particular group of victims, but a substantial number of victims in the criminal justice system. 30% of cases going through Glasgow Sheriff Court are domestic abuse. So it's not insignificant in terms of workload. If you start looking at the situation just for that group of victims, then actually removing the requirement for corroboration means there's an opportunity for the kinds of discussions that at the moment happen in backrooms to be heard in the court. And that's an important part of the process of moving towards justice. We're not going to get there by removing the requirement for corroboration, but we will open up the kinds of discussions about what evidence really is there in relation to violence against women by being able to have those discussions in the courtroom rather than before it gets near the sheriff, mostly sheriffs in our case, I have to say. So I think it's important that the committee takes account of the fact that evidence is sometimes secondary to attitude and prejudice when it comes to decision making, whether at Shrieval level or in solemn proceedings.
To comment to the panel about that, I'm interested.
Well, it's an interesting recognition that the proposed abolition is not going to create a panacea where all ills of the criminal justice system, perceived or otherwise, are cured. And also a recognition, which I completely agree with, that in relation to this particular area of violence against women, that the conviction rate is really scandalous. And what seems to be focused on in relation to abolition is about getting cases into court. No one really concludes that getting all of those cases into court will deal with the appalling conviction rate. And I completely agree that that really is, at the root of that appalling conviction rate are prejudices, attitudes, and that clearly is going to take a further look and further work before we get anywhere near addressing the root of that.
Comment on that in terms of, I know a lot of this debate has focused on corroboration and whether that will make the difference, and I think I absolutely agree that in and of itself it won't, but there are a number of other measures which I think are important that are being considered both as part of this bill and as part of the Victims and Witnesses Bill. The fact that it's only now that we're talking about automatic rights for special measures. Having a screen could be the difference between somebody feeling able to go forward or not. Looking at female forensic examiners can be a massive barrier for some. So I don't think in and of itself it is going to make the difference, and I don't think any of us believe that, but as an important step forward alongside some other really important measures, I think it could make the difference. And whilst the numbers are maybe small, for those people they are very significant, and not just for those people, but the impact in terms of public safety, where there is a high amount of good quality evidence that indicates that they are guilty of this offence, but yet it is not being taken forward. That has a massive implication both for the victim and for the safety of the wider public at large in Scotland.
Anybody else in the panel wish to comment on that? Mr. Mawlowski.
Thank you. I would echo those comments. It is actually wider than corroboration. It's the whole system. And if people feel more confident, victims and witnesses feel more confident, the public feel more confident in the system, they will more likely come forward and say, this has happened to me, can somebody do something about it, please? And that's entirely reasonable. And corroboration forms a part of that, absolutely. And if it allows more cases to be considered, more cases to potentially be based on the fact that there's a reasonable prospect of conviction, and then beyond that, the beyond reasonable doubt test, that is still sufficient. That is still there. That is still there. But it allows confidence in the system, and corroboration forms a very important part of that.
Do you have any concerns, and just again, this is just put you as a proposition, it might have the opposite effect that, and we adhere to change in attitudes and so on, but that if the Crown then feels it must take more cases forward, it's just a proposition, take more cases forward, and lowers its test for reasonable prospects of success against the fact that there's no necessity for corroboration in court anymore. But it doesn't work out like that. It works out that, victims maybe have a harder time in court because the credibility is challenged more and so on. Have you any concerns that it might backfire in a way that was, and people going through the court process, and we have spoken to people who have been through the court process in private who've been let down, feel they've been let down when they've gone through the whole thing and the accused has been acquitted. And that years later, the pain is still there of having gone through it, feeling let down. Have you any concerns that it might not work out the way you think, which is...
I think it is wider than just corroboration. It's the whole system. It's the Victims and Witnesses Bill. It's the journey that victims and witnesses go through, and it's their experience.
Focus on this bill, though, because we've looked at the Victims and Witnesses Bill, and I think we've got a good idea of it, and I think there's many good things in it. But focus on this, and focus on the essential requirement for corroboration now at court level. Let's go to court level with it. Do you have any concerns that we might have in here that in fact, it might not work out the way you think and might have a deterrent effect in people's development all through this for nothing, to be not believed at the end of the day?
That's a potential, but I think our view is that the removal of corroboration is a positive.
Mr Kelly, and I'll come to you, yes.
Yeah, what I was going to say was about the greater expertise of the witnesses from Scottish Women Aid and the Rape Crisis Scotland. Clearly, what's crucially important, I think Mr McCluskey said so, was that witnesses have to appreciate that they're going to be believed. That's the first off, that's what causes them to decide whether or not to report the matter. If after going through the whole process, you end up in a verdict of acquittal, they've not been believed, the trauma is added to, in my experience, and that's what other people have spoken to. And really what you have is that end in itself, is that airing of the case, that access to justice, is that worth, in and of itself, the abolition of corroboration, regardless of the outcome? Because no one, it seems to me, is focused upon what those outcomes will be, or it's disregarded because it's not really something that we have to concern ourselves with. Actually, it may well be crucially important for the victims of crime.
Ms Barton, then I'll take Ms Greenland.
Yeah, there's, I suppose your point about the Crown Office feeling that they should put cases forward. I think the Lord Advocate was very clear in outlining that there would be both a determination about whether it was in the public interest and also whether there was a quality of evidence. So I don't think they will feel under pressure to make a decision based on purely the victim's needs where there isn't the supporting evidence to back that up. And in terms of the court experience, I think court it can be a very harrowing experience for people, regardless of whether there's corroborative evidence or not. I've worked with many women where there is an overwhelming amount of evidence, but that's not the defining factor in terms of how that plays out in court. I think that then is a bit like what victim support were saying. It is about changing the culture. We're doing a bit of research at the moment with people who have gone through court, and some people are saying in terms of judicial protection that there was very clear monitoring of the questioning, saying, is there a point to this, and looking at the relevancy of the questioning, whereas often it is very much about, it becomes a very traumatic experience, but what are we saying that we can't put victims forward because they might have a hard time, that we are doing this ultimately to protect you? I think, and the Lord Advocate had highlighted that not many people would be thankful of you're not going to court because we think it's not going to be a good place for you to be, that's not the answer.
And they're having just now, a harder than...
They have a very hard time at the moment, and I think that is about changing the culture of the courtroom. We have met with Mr McCaskill and talked about judicial training, and I think there is something in there about how you treat victims in a courtroom, but I don't know that the requirement for corroboration is going to impact on that in any way.
Ms Greenan.
Yeah, I think echoing what Sandy has said, it can't be any harder. Like at the moment, victims get grilled in court, they get ripped to shreds in court, whether it's rape or sexual violence. Less so perhaps around domestic abuse, because so much of it happens at summary. And an awful lot of the sort of technicalities of the case are happening much faster, so there's not the playing to the jury element. But I don't think court is a pleasant experience for victims, certainly victims of interpersonal crimes like domestic abuse, rape, sexual assault at the moment. I don't see how that could be worse. I don't see how we could get a worse conviction rate. I don't see how we could get a worse failure rate. So I don't accept those arguments as a reason not to consider abolishing the requirement for corroboration. I believe that the Crown Office, the police and the Crown Office will still look for the best evidence they can. I think that we'll get away from some of the more technical drudges that go on in the system that stop cases getting in simply because there wasn't a piece of DNA that said that man in that place at that time, when there's plenty of other evidence to link them to. We have been accused in recent times online of using anecdotal evidence. Yeah, we have, but if 40 years of anecdotal evidence isn't good enough for this committee and this Parliament, then I really don't know what is. Anecdotally, woman who was beaten so badly by her husband...
I don't know what that's about.
I'm not online.
I'm not online.
Yeah, no, you're not. Sorry, and that's fine, convener. But we're dealing with this issue out with this committee. Sort of thing. So, and it's been interesting looking at the kinds of suggestions that have been made about the irrelevance of the arguments made by Scottish Women's Aid and Rape Crisis Scotland in particular. And I would say this, if a woman who's been so badly beaten that her neighbours fear for her life, who runs into the street with her clothes hanging off her, is not able to get into court because there isn't corroboration that it was him that did it this time, then we have something wrong with our system. And that's the kind of situation that we want to try and address. So, and that's anecdotal, that's fact. That's what happened. It couldn't go to court because there was insufficient corroboration in relation to his presence in the house at the time of the assault. So I think that yes, it is an emotive subject. Yes, it is about anecdotes and stories, but these are real people. So I have some strong views on the need to remove the requirement.
The interesting point about that is I think Lord Gill actually mentioned in looking at a review of evidence, the evidence in Scotland was you look at all the facts and circumstances which might have applied if we had a different kind of evidential base to that kind of circumstance, which I think, I think that's the issue for some on the committee, that perhaps we need to look at the broader evidential basis in court rather than narrow it down to this, and it might have applied in that case, given that there was a history or whatever that it could have done. Would you like to comment on that? That we look at
I think we should
Lord Gill's proposal, that we look at broader aspects.
I think that we can do that whether or not the requirement for corroboration is removed. I think we should be doing that. I think that investigators and prosecutors should always be looking at the full range of evidence that's available and not settling for it. I have a concern that because we have a corroboration rule, there is potentially not a tendency, but certainly a temptation to go, we've ticked the 2 boxes, we can put that one forward. And that's not a critique of how the fiscal service is operating as a rule. It's just a recognition that when people are pressured, they do the minimum they need to do to move on to the next thing that's on their list. So I do think there are some concerns about how it's working currently.
Alison, you're still in.
I'd like to go back to Ms McCall's point about the rights of the accused to a fair trial. I mean, clearly Justice Scotland and SHRC have concerns about the removal of corroboration. We've heard quite compelling stories from Police Scotland this morning and from your own testament there, Ms Greenham, about people who are not able to access justice at the moment. I think in the interests of understanding both of the tests that need to be done, it would be useful if you were able to elaborate on your concerns about the possible miscarriages of justice that might come if corroboration is gone. Perhaps talking about the issues of less credible witnesses and accused people. It would help us understand perhaps some of the concerns that you have.
I think it should be clear, first of all, that the Commission's position is we are not opposed as a matter of principle to the abolition of corroboration. It's not a requirement for a fair trial in terms of the European Convention. But what we are opposed to is abolition in the terms of this bill without proper consideration being given to what may be the impacts of that, what may be the unforeseen and unintended consequences of that, and just how that will play out over, I think, what the Lord President described as centuries of legal development in a finely calibrated system. So undoubtedly persuasive arguments are made, and quite properly so, about more cases getting to court of a particularly difficult nature at the moment to prove. We have absolutely no difficulty with that. The issue is whether we're properly exploring what happens when we're then in the court, which brings me on to your question. Let me just first of all pose this scenario. I listened carefully to the Lord Advocate saying, in terms of the prosecutorial test, that a case would not be brought to court without supporting evidence. I would welcome that. So if a case comes to the Crown Office and there's not that supporting evidence, as I understood the Lord Advocate, he or his representatives will be having a difficult conversation with complainers saying we will not take your case to court because there is no support. The difficulty, though, is if we project our minds forward and we're in the court and it's been taken to court with supporting evidence that the Crown Office had. And in the course of the trial, that supporting evidence doesn't materialise from the witness box. It happens all the time. Witnesses either don't speak up, or there's some flaw in what's happened, it's undermined. For whatever reason, the supporting evidence doesn't pass muster. The judge then will have absolutely no power to do what the prosecutor would have done had he known the situation before the case came to court. So that's why we suggest putting in place, for example, a no reasonable jury power for the judge to say the particular evidence in this case is of such poor quality that it could not bear the weight of a fair conviction. So we say that's a power that the judge should have, precisely to address the problem that I've just identified. So far as the other part of your question is concerned, in particular types of evidence that cause us difficulty, the Strasbourg Court has been very clear that there are some types of evidence that are inherently unreliable, and when cases involving that type of evidence come to Strasbourg, the first thing they do is they look for corroboration. Now, as a matter of fact, not as a matter of a legal requirement. But those are, for example, hearsay evidence. And Lord Gill, the Lord President, in one of the cases in which he issued the opinion, said that the protections they have in England in relation to the quality of hearsay evidence that's admitted into the trial are not present in the Scottish legislation, they're not present in common law, and his word was they would be prudent to be there. So that's one example. Another is doc identification. Lord Carloway, when he gave evidence to the committee, said that, of course, there are other safeguards in place, and so the Judicial Committee of the Privy Council told us that doc identification is convention compliant. The other safeguard they talked about was corroboration. So you're taking that away. That's why they don't allow it in England. Evidence from anonymous witnesses and undercover police officers is another area of concern to Strasbourg, because it's very difficult for the defence to challenge the quality of that and ensure the integrity of that evidence. So there are all these sorts of types of evidence, and we've listed them in our written submission. I don't need to rehearse them all with you. These are far removed from the types of evidence that one is looking at in the cases that the other panellists are dealing with day and daily, to do with domestic abuse, sexual violence, and so on. But it gives an example of the breadth of the implications of abolishing corroboration across the system. And whilst understandably the committee's focus has been directed much of the time to those very difficult types of cases, we're talking about a proposal that will cover everything. And that's why we have the concern that time should be taken to look at it properly. I don't think that need take a long time. I agree with the Lord President about that. I don't think it's about kicking it into touch or anything like that. I think actually it can be done relatively quickly in a participative way, so that all those with expertise can input into the consideration of it, and a proper view be taken about whether, in fact, this is the right way to do this, or whether there's a better way to do it.
I've got a list, so I'm going, Sandra, I'm going to let everybody, I've got a lot of people waiting, and it's all on the same stuff, so it will all be... I think that probably on that particular issue will be followed up by others, if you'll forgive me. Roderick, followed by Christian, Elaine, Sandra, and then Margaret. So you're on the list already.
Can I refer to my register of interest as a member of the Faculty of Advocates? Mr. Cole, you've referred to the reasonable jury point. We've heard evidence last week, I think, from the Faculty of Advocates that 2 points that Lord Carloway had made in opposition to that test. One is that it might slow the process. The Faculty of Advocates' evidence was that we have a similar situation now in a no case to answer thing, and where an appeal court can be convened quite quickly if it's thought that the decision an individual judge has made was wrong. So they didn't accept the delay point. Perhaps I'd ask the rest of the panel. I think Victim Support Scotland, and indeed I think it's Scottish Women's Aid, were against, in the government's second submission, against this proposal. Perhaps you could expand, or the panel generally would like to comment on what's been said on the reasonable jury point.
Who wants to comment first?
The Scottish Government in the policy memorandum indicated one of the reasons they hadn't proceeded with this safeguard is because of opposition from victims' groups. I'm giving you the opportunity to perhaps expand on that.
You're talking about, Roger.
It's the safeguard. It's the judge having the opportunity of withdrawing a case from the jury where he thinks that no reasonable jury could convict on the nature of the evidence that's being presented. It was one of the 3 safeguards in the second consultation.
On record in front of this committee previously as suggesting that Shrieval education should be quite high up the list of things we need to do in terms of safeguards for victims and judicial education. I think there is a concern from our perspective that decisions are sometimes made not just by juries based on attitude and assumption and prejudice, but also by judges and sheriffs. So that would be our concern about giving that discretion to judges.
Any comments from Mr. McCloskey? I mean, you were opposed to it in your written submission to the second consultation.
That would remain our position on that.
Nothing else to say on it?
That would remain our position.
No. Mr. Kelly, do you want to comment?
Just very briefly.
Now, but I really don't mind. I don't mind. I can go to sleep.
I just want to make sure.
I can just go to sleep and pass the list over. It's okay, Mr. Kelly.
Just very briefly, without that safeguard in place, as Ms McCall correctly points out, once the case gets to court, there is no judicial input whatsoever to determine on the questions of sufficiency, quantity or quality. The matter will then go to the jury, and the only safeguard, if it be one, will be the decision of the prosecutor to decide if the factual scenario that Ms McCall played out comes to be that perhaps the evidence is satisfactory, that would not have been proceeded with if we had known what was going to happen in the trial. Then the only safeguard would be the decision of the prosecutor to basically pull the case. Absent that, then the matter proceeds to the jury without this safeguard in place about the judge being able to determine that no reasonable jury would return a conviction.
The defence can't say there's no case to answer. Can you explain that to me, what the defence can do in those circumstances?
Well, I'm talking about post-abolition.
Yes, so am I.
There would be no question of no case to answer because this question of sufficiency would fly off. There is no way that we can judge sufficiency now in the absence of corroboration, because that was the only test for sufficiency.
Which, for the record, if you'd explain just now what can happen.
At the end of the Crown case, the defence can make a no case to answer submission saying that the Crown case at its highest doesn't meet the test of sufficiency, of a minimum test of sufficiency of corroborated evidence, and therefore the case can't proceed to the jury. If you abolish corroboration, then no case to answer must fly off. And if you don't put in a further safeguard about no reasonable jury, the judge has no power whatsoever, post-abolition, after the trial starts, to rule upon the question of sufficiency of the matter going to the jury.
Thank you. Can I just ask, can you tease out, I'm hearing what you're saying about judicial training and Shrieval training, can that not be done detached from this? I mean, should that not be happening anyway?
It's ongoing. It's a work in progress. And yes, like everyone else in the system, judges and sheriffs are like the awareness changes over time. This is a long game. You know, like this isn't something that's going to be fixed in a year or 2 years or 5 years. It's a generational culture shift that is required in order to address the particular issues of violence against women differently in the justice system. I'd like to, if I may, pick up on something that Tony Kelly said there about no reasonable jury. That kind of makes the assumption that juries are reasonable, and I don't intend to be contentious about this, she said, but I have only one. I'm going to be contentious. I only have one experience of being on a jury. It was a long time ago.
No, you can't. Can I caution you?
You
can't
yeah.
discuss having been on the jury and what took place.
Okay, I won't discuss what took place. Am I allowed to say a very general line?
I think I would caution you against doing that.
Okay, it's fine. From my experience of the past 35 years of working in the field of violence against women, can I say that juries have sometimes made decisions which beggar belief? And without adequate research on how juries function, as I understand it, we still don't have legislation in place that would allow that to happen, although I believe from Sandy earlier today that there has been some research in England and Wales. We don't actually know what a reasonable jury is. It's a jury of our peers, and that actually in practice appears to mean a particular demographic of people who are available during the day. From the work that I did.
I think in fairness, I mean, I think people have to leave their work and do it. They're not, I wouldn't call it available during the day. I think you're very, I don't think you're allowed to get off jury duty that lightly.
This dates back to the research that was done around the establishment of the Domestic Abuse Court, and that had a bit of side research looking at the makeup of juries, which wasn't about jury functioning, it was just about the makeup. So I'll take that out. But I just think that it does, for me, raise a question about what a reasonable jury is and how that is assessed in law.
You look as if you're at the starting gate.
I'm just about to,
yes.
If I'm allowed. I'm sort of using a shorthand, no reasonable jury. The full safeguard would allow the judge to arrive at a decision in law that no reasonable jury, properly directed, would return a verdict of conviction. Now, of course, the answer to that always in submissions that I've come across is, are you saying this particular jury was unreasonable? And of course, then you're into a discussion about that. But the thing I'm talking about is judicial input, and the test is that no reasonable jury. I'm not questioning whether juries are reasonable or asserting that they always are. This is a judicial input that represents a minimum safeguard post-abolition.
Roddy, do you want to? Somebody else want to come in, or Roddy, do you want to come in?
No, I would have a couple of other points.
Yes,
if
go
I
for
can.
it.
Firstly, hopefully briefly, something we haven't touched on this morning is the question of jury size. Mr. Kelly, in your written submission to the second consultation, I think Justice posed the question, what does proof beyond reasonable doubt mean in terms of the size of a majority jury verdict? Just wonder what the panel's view was in terms of the proposals in the bill.
Well, I think what Justice Scotland's view was that there was nothing particularly sophisticated or scientific about plucking the magic figure out and then pushing the majority figure up, and then there was a tweaking of it as well in the event of jury members falling out, and that didn't attach a magical significance that then there would be proof beyond reasonable doubt. And I think in the absence of any research or further work, we thought that was quite blunt to remove abolition. And I have to say I agree with Lord Gill that as soon as you recognise that there has to be a tweaking of the majority verdict, then you recognise that what you're doing post-abolition is completely changing the field.
Wish to comment on.
In Lord Carloway's review, he didn't think that there needed to be a changing in the majority. In some ways, it feels like it's almost in response to a kind of popular opposition to corroboration. I mean, we were opposed to an increase in majority partly because, as Lily highlighted, what we know about prejudicial views, particularly in cases of sexual violence. And there has been research conducted. I know there are limitations in the research you can conduct with juries, but there has been research conducted in England using real transcripts of court cases to look at how decisions are arrived at, and much of it is not really down to legal fact and argument. It is very much based on some of the myths. If it were me, I would have fought to the death. If it were me, I would have told straight away. So all of those rape myths are played out in jury decision making. Research that the Scottish Government have commissioned highlighting, a quarter of people still believe a woman is responsible, partly responsible if she's been drinking, a quarter if she's been wearing revealing clothing. So in terms of changing the majority and increasing the majority, I think we do have concerns about what that's going to mean in terms of the likelihood of reaching agreement or reaching, given also what we know about the use of the not proven verdict, particularly in sexual crimes, which is disproportionately higher than in other crimes.
Well, surely what you're saying then, if you abolish the requirement for corroboration, it'll make it worse, because the juries who you're saying are quite often perverse will have nothing else, perhaps, than credibility, and make an acquittal or a not proven more likely.
I suppose that there's the corroboration and there's the jury majority. I know that the bill proposes it to be increased.
I'm talking about the way juries think, according to yourself, as you're saying, that if they've got corroboration, in the face of corroboration of a sexual offence or rape, they at least have to face up this corroboration of the event.
Absolutely.
But if there isn't any, then what would concern me is, from what you're saying, is the jury is even less likely to convict.
And I suppose that's what has concerned me about a lot of this discussion, that it's either it's totally met or there isn't any at all. And I think what we're talking about in the vast majority of cases is that there is supporting evidence. I think the Lord Advocate's examples are very clear that there is a lot of supporting evidence, but in some element of the case, it's not corroborated. So, of course, if there was only one witness, and I think there's been much of that, it's only about one witness, somebody decides. And I have to say, I think some of the debate has been very much, the underlying discussion is around false allegations, this misconception that women make up stories, make up false allegations. So I think that has underpinned some of the discussion. But in the vast majority of cases that we are talking about, and that the Crown Office and the police are talking about, there's a significant amount of evidence, but they're still not getting to court.
I actually think we've had an awful lot about false allegations. It's obviously been dealt with, but I don't think it's dominated the discussions about corroboration and so on. I really don't think that's the case. And I'm looking around the committee, and I think that is the point. It's been raised, as it must be raised, but it hasn't dominated the discussion.
Yeah.
Certainly hasn't.
Yeah, not necessarily in here. I'm talking about in terms of some of the media reporting.
We don't care about the media in here. We've integrity in here. We're just looking at the evidence that comes before us. Roddy? Yes, you can.
We've dealt with two of the safeguards in the government's submission, or proposed safeguards. I wondered whether the panel had a view on whether there should be other statutory changes, such as something equivalent to Section 78 of the Police and Criminal Evidence Act in England. And also, the bill as proposed obviously doesn't have any additional safeguards in relation to summary cases if corroboration is removed. And just to comment on that. So those two aspects I'll be interested to hear from the panel.
My view of those is that all of those potential safeguards are suggestive of the fact that this is such a big topic that it really requires, rather than amendments be made that tinker with the criminal justice system as a whole and how it operates. It's something that requires really a greater study about the effect of those safeguards. So it's the effect of abolition, which there's some controversy about, and the effect post-abolition of the proposed safeguards, for example, in relation to Section 78, the no reasonable jury, and the question of majority verdicts. At the moment, the government consultation paper that prefaced those particular safeguards, well, two of them, there was a very brief discussion about them, and no, as I said before, in relation to the question of majority verdicts, no particular sophistication or any sophisticated analysis of the effect of that particular safeguard. So those, as a whole, suggest to me that the matter really is worthy of further investigation and further analysis.
Anyone else wish to comment? Ms. McCall.
We've said, as Mr Campbell knows, in our written submission that the introduction of something like Section 78 of PACE, which put short, is a power for a judge to exclude a piece of evidence if allowing it in would compromise the fairness of the trial beyond the point where that's tolerable. We've said that would be a good idea. There is some suggestion from Lord Carloway, I think, that Scottish judges already have that sort of power, that if the trial is going to be unfair, they can exclude evidence. I don't necessarily agree with that. I think the Scottish power is much narrower. And in support of that, I would point to the fact that the Commission can find only 2 cases reported in which the court has considered that power and exercised that power, and they are both cases involving Lord Gill on appeal. So I think that is one thing that could be done, but I suppose if I hark back to where all of this process began with Cadder and the emergency legislation, the committee knows that the Human Rights Commission is on record for criticising the government for legislating in haste and potentially repenting at leisure. Here we are, we would say, about potentially to do the same again in relation to the abolition of corroboration, because as yet, whilst there's no objection in principle to it, no one has done a proper analysis of how that impacts the rest of the system and how that may impact on fair trial rights. So whilst we can sit here and give you examples of alternative safeguards from other systems and so on, I cannot possibly suggest that these are the answer to all the problems. One needs to do the proper scrutiny. And more importantly, the question of a fair trial is a legal matter. It's a question of law. And so you need to give a judge the tools in order to fulfil his duty to meet the requirements of the law. And without going through that exercise of saying what tools will a judge need if we take away the corroboration tool, we may be, in quite real terms, increasing the risk of unfair trials.
I'm going to move on to, I've got lots now. Christian, Elaine, Sandra, Margaret.
Good morning. Just to, it should be good afternoon now. Just to follow up on this, we talk a lot about the removal of corroboration. Now, I would like to have your thought on this. Out there in the media and in the debate so far, we're talking about the removal of corroboration as opposed to requirement of corroborations. But do you think that, after the evidence received from the police this morning, that in fact very little cases will come forward without corroboration, but there will be corroborated evidence and there will be corroboration? Or do you think that will be an incentive for cases to go forward, which, I'm not talking about the isolated cases that we're talking about, but other cases, solemn cases or other cases, will go forward without corroboration just because requirement has been taken away? Can you quantify this?
Cannot quantify that. I didn't hear all of the police evidence this morning, but from coming in at the end, I got the gist of what they were saying, I think. Let me put it this way. As I said at the beginning, there seems to me to be no doubt that removing the requirement, the technical requirement for corroboration, will increase the numbers of cases the police can report to the Crown can take to court. There's no doubt about that. I don't think anyone suggests that there is any doubt about it. In terms of whether ultimately cases will come forward from the police to the Crown without supporting evidence, I don't know. That's a matter for whatever the directions of the Chief Constable are at that time. Whether the Crown, through the Lord Advocate, not the present incumbent, but a future incumbent of that office, would change the guidelines, I don't know. What is meant by supporting evidence, I don't know. What level that will reach, I don't know, because until we test all of that, we don't exactly know what it's going to look like. So one may say, for example, in a rape case, we will have all the supporting evidence you would normally expect now. The only thing we won't have to do is corroborate penetration, which is a very difficult thing post-CADR. I accept that. That may be so, that may be fine. We may always be in that position. But when you're at the other end of the criminal justice system and you've got a 16-year-old boy charged with breaking into a car, are the police going to investigate as thoroughly? I don't know the answer to that. The police are the ones to answer that question. So I don't think any of that is quantifiable. But I don't, with respect, think the issue is about what gets to court. I think the issue is about what happens once you're in court. And those of us that work in courts know day and daily the supporting evidence doesn't always come up to snuff. And then the judge has no power to do anything about it. That's the point that we're making.
I think that the quality of corroborated evidence is not always up to scratch.
Well, I think every prosecutor or defence lawyer or judge will tell you that day and daily in courts, witnesses come and their evidence isn't what on paper it's expected to be. And if that happens in a case and you're left, the remaining evidence you're left with is of poor quality, whatever that remaining evidence may be, but if it's of poor quality, we're not giving our judges the power during the course of the trial to do anything about that to ensure a fair trial. That's the problem. Currently, they have some power through the corroboration requirement.
Any other?
Yes, a Margaret Mitchell moment. Yes, I don't mind. We're adopting it now, yes. I'm just laughing because I usually get to call witnesses, but they're all doing it themselves now. So that's all right. I'm devolving power down to them. Right. Ms. Barton.
No, I was just going to say, if presumably in terms of the collection of evidence beforehand and that decision about whether there's sufficient evidence to get to court, however that is played out and whatever materialises, that you anticipate something and it doesn't happen. If the decision is no reasonable jury, if that's the decision, then, but it's already being heard in front of a jury, then maybe it should be left. to the jury. If it has passed the bar in terms of getting into the court, then I would say it's in the court process and it's up to the jury to make that decision. I mean, it is beyond, I think the bar is beyond a reasonable doubt, which is a fairly high bar to meet. I'm being asked, and this is absolutely irrelevant in some respects, so I'm certainly not going to agree to it unless you agree. I think photographs to be taken for the reasons of the press. I'm only allowing it if you're not unhappy about it. You're unhappy about it. Do you want to comb your hair first? Thank you. I don't know who it is, but I'm certainly asking the witnesses. You're quite content. Thank you. Yes, you may. Right, proceed.
On that particular point, the artificiality of it is this. The appeal court overturns verdicts of juries on the basis that no reasonable jury properly directed could have come to a conviction. What we are saying is, rather than go through the entire appellate process to the same outcome, give that power to the judge the first time round. And if the Crown want to appeal it, the Crown can appeal it. That can be facilitated. It's facilitated now with no case to answer submissions. If the defence want to appeal it, they can appeal it at the end of all the proceedings in the usual way. So, whilst I appreciate there are often verdicts of juries that surprise everyone, what we're talking about is a legal test that already exists, and we're just talking about putting it into a forum where it can be utilised at the right time. I think we've tested that. If you let me, committee, forgive me, move on. I think we've got the gist and that test that's not going to be there. Elaine, Sandra, Margaret, John. We would like to finish by 2. Concentrate minds. No, aren't they? I know you are. That's why I'm moving along. Elaine?
Right. We've been hearing about some of the problems that corroboration creates for particularly one-on-one type of crime, such as rape and domestic violence and so on. But however, the removal of corroboration will, or the removal of the requirement for corroboration will affect the entire criminal justice system. So is not another option the possibility of reforming what is considered to be corroborative evidence? Because corroboration has changed over the years anyway. I mean, things like Murov have come in and so on, so the actual what is considered to be corroboration has changed. Is it not a possible alternative to look at further reform to corroboration to deal with some of the one-on-one crimes, such as domestic abuse or sexual violence, for example, to allow something like the distress of the victim to be considered to be corroborative evidence in those crimes without having to change it for everything, including shoplifting or whatever? So, you know, somebody could accuse me of shoplifting and I've lost the receipt and, you know, there's no further evidence.
Is this
I could
a
be taken to court.
confession?
No,
that's not a confession.
No, I haven't lost. But that type of, the removal of corroboration will affect a whole range of other crimes. Is it not possible to reform corroboration so that victims of domestic abuse, victims of sexual violence, have a greater access to justice, but without affecting the whole of the rest of the justice system?
Are you suggesting that an alternative would be to remove the requirement only in relation to crimes such as...
No, I'm suggesting that actually the definition of corroboration could be reformed, or that, I mean, that alternative has also been suggested to us, that it was removed for certain crimes but not for the entire system.
I think we've argued that we shouldn't be looking at removing the requirement only for certain categories of crime. The justice system should be a justice system for everyone on an equal basis. So I think that, you know, it's a bit of an all or nothing for us on that one. In terms of looking at what else you might do to broaden the definition or to... My understanding is, and I'm not a lawyer, but my understanding is that corroboration as it is now is not what it was when it first came, you know, into sort of common use. That it evolves over time, that bits and pieces of it get tinkered with, that there are different ways to look at technical corroboration of evidence. So it is in a constantly evolving state. I'm not sure about whether you can codify that in statute and say, so we'll do it this way, we'll add this in, or we'll allow this. I don't know enough about how that would work technically, Elaine.
Well, would that be an alternative to the blanket removal of the...
I think, I mean, yeah, maybe it's worth having a consideration of. But I'm not sure how you would do it in a way that's different from the way it's been evolving over the last couple of 100 years.
Can I ask if anyone else wishes to make a comment with regard to Ms Barton.
Yeah, I know that the cross-party working group on child sexual abuse have argued a third way and have looked at that sort of reform. And in some ways I think it's unfortunate, because I think that the ultimate aim, that their ultimate goal is the same as ours, and I think in some ways they're at odds with the rest of the victim organisations, because it says clearly in their evidence submission that what they would like is that the opportunity for justice and for more people's cases to be heard. I think there is an opportunity. I mean, I think what we are proposing isn't about abolishing corroboration. It is about looking at how do we apply that as widely as possible, and it is about supporting, looking at supporting evidence. But the narrow definition at the moment is so narrow as to be, as Lord Calloway said, an impediment to justice. And I know there's been a lot of discussion about miscarriages of justice that might happen, but I think for us it's about the miscarriages of justice that are happening currently. I welcome, I looked at some of Lord Gill suggested some other areas in terms of evidence that we could review, and I think that would be helpful. I know that there are other provisions, other plans to look at, for example, a not proven verdict, so I don't think this is the only opportunity in terms of looking at our criminal justice and getting it right, but yeah, we support the abolition and look at a much wider supporting evidence in terms of cases.
Does anyone else wish to comment? Ms McCall.
Concern would be, if the bill goes ahead and you abolish corroboration while you do those other things, what happens in the interim to those people going through the trial process while the other changes are made and review is had of the law of evidence? That's why we say in principle there's not an issue. But the way in which this bill is doing it is the potential problem, and time should be taken to do precisely what's just been suggested by the witnesses here and by Lord Gill and others, is to review properly the implications and the other adjustments that may advance the system.
Do you think that the possibility of the redefining of what counts as corroboration might be part of that?
Well, I don't see why that should be off the table if you're reviewing across the system of evidence, because it's about, you have to look at future-proofing the system too. So what the committee should be guarding against is making a change now that later has to be adjusted in some other way. So I don't see why that should be off the table. I mean, I've made the Commission's position quite clear that we don't have, in principle, an objection to the abolition of it, but proper consideration.
Mr Kelly, are you at the starting block again, or you're not keeping a pace with us in here? We're Sandra, followed by Margaret, followed by John Pentland, and then I will bring this to an end because we've got other business. I'm sorry.
Thank you very much, Convener, and good afternoon. To pick up on Ms McCall's point, yes, she certainly did say that you're not against the abolition of corroboration and put forward a number of ideas. But the reason the government didn't pick up on one particular one was withdrawal of the case from the jury, was that the judiciary and obviously groups as well were very much against it. So I think you were on your own in that particular aspect of it. So I just wanted to make that point as well. And when you talk about... I'm coming into a question. I'm allowed to comment, surely.
No, just clarifying, were the judiciary against it as well? I can't remember that bit.
It's in the report.
The majority of the judiciary were against it. Minority of judges supported the line that Mr Kelly and Sheila McCall have. And I think also the submission figures were 20 in favour of the judge having the power, only 3 against.
Thank you for that. I just wanted clarification.
Yes, absolutely. I'm sure Ms McCall would have clarified it herself anyway. The other point I wanted to raise as well was in regards to the Strasbourg Convention, the court. You mentioned about them in corroboration, but obviously also, I mean, you've got the Supreme Court of Canada, you've also got the United Nations Committee on the Elimination of Discrimination Against Women, and if I can find the other one which I mentioned previous as well, was the International Criminal Court say there's no requirement for corroboration. So I just wondered why obviously you picked the Strasbourg one, because obviously they're in favour of. Now, would you disagree with these other courts then when they say there's no requirement for it?
No, I wouldn't. But what you have to understand about those other systems is that they have other safeguards to deal with the quality of evidence. So, as I understand it, the International Criminal Court has a rule about the admissibility of evidence of insufficient quality and so on. It has, as I understand it, the equivalent of a no reasonable jury type test. So the difficulty with looking at other systems and saying, well, they don't have it and they do just fine, is you're comparing apples and pears, because what is unseen in those other systems are all the checks and balances that start from, for example, in England, from the point of investigation, all the guidelines in the Police and Criminal Evidence Act about how evidence is gathered, how it's recorded, how it's disclosed, then the prosecution test, then the safeguards in terms of the trial. So, no, I don't disagree with these systems, but they do have other things in place that prevent or guard against the sorts of dangers that we're identifying. The difficulty for Scotland is, in recent years, those safeguards that we had that allowed for some quality control have gradually been abolished. So, for example, in relation to the no reasonable jury point, at common law, that power existed in Scotland until 2010, until the Criminal Justice and Licensing Act. And judges, it seemed to me, had no difficulty in applying it. And I'm not aware of a flood of appeals that suggested there were idiosyncratic decisions being made by judges on that basis. Now, it was a relatively limited power. It was very rarely used, but nonetheless it was there. But we've abolished that. And one or two other examples that could be given if necessary. So.
There's safeguards being put in place, and also the government have asked, people to, groups like yourselves as well and experts, to bring forward other safeguards. So I don't suppose you're saying that there are no safeguards there if there is an abolition, or maybe I'll open that up, if there is abolition of legal requirement and technical requirement of corroboration. You're not saying that we're just going to put it in without safeguards. I would like to open it up to see if anyone else has a comment in about that.
We are to some extent saying that because one has to think about how it is that corroboration acts as a safeguard. And it acts as a safeguard because, yes, it's a quantitative issue, we all know that, but actually, in its essence as a safeguard, it's a measure of quality control. So it allows a fact finder, a jury or a judge to say, in order to decide whether I'm going to believe that main piece of evidence, is there something that supports it that I do accept, that backs that up and that gives me confidence in the quality of that main piece of evidence? That's how corroboration operates as a safeguard in this sense. If you take corroboration away, we don't have any means of preventing evidence of extremely poor quality ending up being the basis of a conviction, because we don't have the no reasonable jury, we don't have a proper exclusionary rule like Section 78 of PACE, and so on. So, from the point of view of quality control, there is nothing obvious that remains once you remove corroboration. There may be safeguards about jury majorities, maybe safeguards about the standard of proof and all of that. No doubt those are safeguards, of course. But what Strasbourg says is important is giving an accused person an effective and proper means to challenge the reliability of evidence and have it excluded if appropriate. And that's what will be lacking.
Yeah, but when we talk about, obviously it was raised before in the previous evidence session, about miscarriages of justice, and it was mentioned about the English, the examples from down there, but not from Scotland. But when you've got something like 3,000 people who are not getting access to justice, is that not against their human rights as well?
That's why I said the challenge for the Parliament, I said that right at the beginning, the challenge for the Parliament is fulfilling the right to an effective investigation and prosecution for people who are victims of serious crime. I mean serious, back to Ms Green's point, in the European Convention sense, not necessarily in how domestically it's treated. So offences against the person and so on would tend to fall into that category. So yes, the Parliament has to achieve that, and yes, there is a problem for victims of particular types of crime getting their cases into court. We've acknowledged that. And one of the answers to that, yes, is the abolition of corroboration, because that will undoubtedly increase the opportunity for cases to get to court. What we're very concerned with, though, is what happens in the court and the lack of adequate safeguards then to protect the fair trial, which is why I say in principle we're not opposed to its abolition. We're saying it just needs to be thought through.
Mr. Kelly.
Mr. McCluskey wanted.
No,
sorry. Okay, Chair.
It's all right. It's all right. I'll take a vote on it.
I saw Mr.
Kelly.
Just very briefly, I would just echo those comments. The Strasbourg court doesn't require corroboration. What it looks at in the round is whether there has been a fair trial in terms of Article 6 of the Convention. So it's not a requirement of Article 6 that there be corroboration. But whenever Scottish cases have gone there, or even when Scottish cases have been discussed by analogy with English cases where Article 6 has been analysed, the first stop is corroboration. You take that away, as is proposed, with nothing in its place other than the one safeguard which is proposed at the moment is majority verdicts for juries, which wouldn't apply in the vast majority of cases which go before a sheriff, then it's very difficult to see what the argument would be when Scotland gets to the European Court of Human Rights to respond to a complaint from an accused person that he's not had a fair trial. Because to look at the safeguards in a summary case, it would be a very brief discussion. There aren't any. The one that we constantly harp on about just now is corroboration. That's our first stop. We don't have that. And in a summary case, there's nothing else. It would seem that it's probably irresistible, the conclusion that there would be an unfair trial in a breach of Article 6. One of the ways to avoid that is to look at the other safeguards that have been proposed, to introduce those in a wider context. I think that involves a wider appraisal of what the criminal justice system is about and what those safeguards are intended to ensure post-abolition.
Yes, Mr McCloskey.
Just a couple of points that you raised earlier, Sandra, about the quality of evidence. And it is about the quality of evidence, not necessarily the quantity. And I think that's the overriding principle. The criminal justice system must be human rights compliant for all. That's for victims, witnesses, as well as people that are accused. That has to be overriding. And I do think there are safeguards in the system. As I said previously, it's about the cases will still need to have a reasonable prospect of conviction, and the jury or the judge has to consider the evidence beyond reasonable doubt. Those are still there. They are still absolute cornerstones of our system, and they should remain.
When I was listening to was Ms McCall's evidence that the Crown might very rightly think there's a reasonable prospect of conviction on the statements and the evidence they start out with, but it doesn't always turn out like that in court. You know, the witness that you think is going to say something says something completely different when challenged. So I think we're not saying that the Crown hasn't done that, applied that test, but once it gets to court, sometimes these can unravel. And I think the point that Ms McCall is making is, at that stage, there should be a prospect of saying what I would call a no case to answer, certainly for the judge to say no reasonable jury would convict in this, because the evidence has turned out differently. Would you see that can happen?
I could see that could happen, but what have we got now that's sometimes failing victims and witnesses? And there are miscarriages of justice where there has been an offender who's walked away free and the victim's left.
I'm specifically testing you on the business of the judge being able to say there's, you know, the insufficiency of evidence here to a jury is able to say it, given that the evidence that the Crown quite rightly has taken has not turned out like that in court. Would you see that there's a purpose in that, and that would be...
I can see that as being...
do you think we should have that?
I think that's something that could be considered. I think that would be
I think that's the point that was being made by... I hope I've understood. Yes.
Can I just follow up, please? I'm sorry. Just a quick one, and it was to pick up on what Sandy and Lily had said as well, to take it in the round, basically, as well. I just like either yes, no, or whatever it may be. You know, we've heard about, basically, corroboration is just one part of it. And I did ask this of the Lord Advocate as well, in regarding the cultural system within, not just our country, but within juries, within the judicial system. Sandy had given an example of a woman has drunk too much, or she's, you know, dressing a certain way. If we get rid of this legal and technical form of corroboration, and more cases are deemed to go forward by the prosecution, the Crown Office, surely, in my opinion, I don't know about your opinion, surely if that's heard, hopefully, eventually, juries and judges, etc., as it comes forward, more of them come forward, you would hope that the cultural system would change, because all of a sudden people are being confronted with these sometimes horrific stories, not stories, but evidence, horrific evidence, that they wouldn't necessarily have heard if it hadn't went to the judge and the jury trial system. And through time, people won't be quite so, I would say, I hate to use the word blasé, but sometimes when you see some of the decisions, it seems quite blasé. I just wondered if that, in a long term, would help change the attitudes of people towards people who have suffered sexual abuse and domestic violence as well. Sorry.
Others are perhaps better placed to comment on that, but you mentioned, Ms White, the committee for the elimination of discrimination against women and their observations about the problem with corroboration. And the Commission made a submission to that treaty body, and what we said was that there needs to be a comprehensive strategy for violence against women. And not only needs there to be a comprehensive strategy, but there needs to be an action plan in terms of how to put that into place. One part of that is undoubtedly the criminal law. There are other parts of that which others are better placed to speak about than I am. But it's important to understand this is the issue of the appalling conviction rate is a wider one than the existence of corroboration. I think that's already been acknowledged. Undoubtedly, corroboration is an impediment to getting cases to court for some types of crimes, but there needs to be a much wider strategy to try and shift those cultural norms, if they are norms.
Yeah, unfortunately, I think they are norms. I would echo that. I mean, I think our sort of focus on moving towards the abolition of the requirement of corroboration is part of a much wider drive, which, you know, we do a lot of work jointly with the police. I was heartened to listen to Malcolm Graham and echoing a lot of our thoughts in terms of corroboration. We do a lot of training with the police. I think we have prevention workers across Scotland looking at how we change values and attitudes. So I think it is part of a much wider cultural shift that we need to be making, but I think it is an important part in terms of the criminal justice system.
As time's going on, we've got more work to do on our agenda that I can't park. Margaret, followed by John Pentland. That'll be the last question.
I mean, this provision about corroboration in the bill has been brought through because of the lack of convictions in interpersonal assaults and crimes. And the assertion has been if you get rid of corroboration, you will get more prosecutions. Can I maybe turn it round and see if there's another way to look at this? It's clear that court practice just now is not looking at some of the evidence that could be used to establish corroboration, and that could change circumstantial evidence, hearsay rules, the testimony of expert witnesses, and that it could help victims immensely if these rules were changed and these cases were brought to court on the prospect of a conviction, by having the certainty that that corroborated the evidence and therefore made the conviction more secure. Now, the other side of the coin, and the view that's been expressed is quality, which is perhaps subjective, sufficiency of evidence, subjective, much more so than has this been corroborated, yes or no. So I suppose the proposition I'm putting to you is, would you rule out retaining corroboration and looking at these rules of evidence to make it more secure, and in doing so, guarding against what Ms McCall has expressed as a very real danger, the accused then being able to cite not having access to a fair trial?
Barton or Ms Greenan, which?
I mean, I welcome some of the suggestions that you make in terms of what could be included. I suppose our concern is if you have rules, you have exclusions, and that by removing the requirement, you still have that flexibility in terms of building up that case and building up that picture of supporting evidence. But were you to be prescriptive, and again, I'm not sure in terms of the rule of law, but how this would count and this wouldn't, and to be so exact. But I think as much as possible, the police and the Crown Office are looking at what is the broadest picture that supports the complainer's version of events. So they are looking at that, and I'd welcome the widest application of that. But I think the requirement, and it's in its technical form, does need to go. And also just to clarify that this hasn't been brought about as a result of the low conviction rates, because the conviction rates have been pretty abysmal for a very long time. This has come about because of the Cadder ruling, and whilst there's been a real focus on the rights of the accused, I think those have increased their rights have continued to increase without any commensurate increase in terms of the rights and the protections that are afforded to victims.
Or anything from the evidence today, but they have all this evidence, but the Crown doesn't take into account the circumstantial evidence in the case that you cited as a very compelling case at the very beginning, Ms Greenan. Then that would be taken into account, and that would help it to go to court, and that would be counted toward establishing corroboration in a way that it hasn't been. So I suppose, without getting into the nitty-gritty of every single thing that could be done, isn't there a case for at least considering retention and looking at the law of evidence to improve corroboration, because it is so much easier to say, yes, we have a conviction because we have corroboration, and corroboration has been made easier?
It sounds to me, Margaret, as if you're proposing a similar thing to Elaine's proposal earlier around looking more widely at what corroboration is, what counts as corroboration, what supports it. So I think, I've already answered that, I feel, in my comments earlier. I do think that anything that makes it more complicated is going to be harder when we're talking about solemn proceedings. I think that technical directions to juries are problematic in terms of what counts and what doesn't count. I have a concern about adding more layers into something that is already problematic in getting cases into court, and I'm not sure how I'm not sure what you're saying that is different from what's been said earlier around.
Looking at the subjective element, which you've already said exists in juries, where I may think that's real quality evidence, but somebody else doesn't. And therefore, it isn't as clear-cut as, was there corroboration? Yes, no. Much more difficult for a jury to be subjective about.
It's still going to come down to how it's played by the prosecution and the defence, and the extent to which actually the evidence isn't the issue in these cases. The issues are, did she consent or did she not consent? Attitudes playing their part in the defence case around notions of consent and what women are responsible for and what they're not responsible for. And in relation to domestic abuse, if it's that bad, why is she still there? Like the attitudinal stuff, which can come into play, I think, overrides some of those evidential requirements.
I think that's my fear, that by going to sufficiency and quality and not looking at the quantity which establishes corroboration, that's merely going to continue.
Move on to, I'm sorry, I know I've had a fair whack, but John, you'll be the last question as usual.
I think probably this is the first time where we've seen the witnesses being for and against, and I think it's probably been quite the interaction, I think, is to be congratulated. But could I just maybe ask a question of each of you individually, and for those organisations that you represent, what would be the consequences of corroboration if it were removed?
Removed?
Yeah.
I believe that the numbers were 2,800 incidents didn't proceed, domestic abuse incidents didn't proceed beyond police reporting. And so, and a small proportion of those would pass the new prosecutorial test. It's only about 1.5%. So in terms of numbers, not a huge amount. In terms of being able to have the debates in the court rather than in the fiscal's office and with the solicitor, I think that it opens up. For me, it would be about looking at the longer term. Sandra mentioned earlier the contribution of removing this requirement to a longer term cultural shift, an opportunity to have the discussions and probe the issues more in the courtroom using quality evidence rather than a technical number of pieces of evidence as the way forward with that. So I think it's part of a long strategy. I agree with Sheila that what we need is a violence against women strategy and an action plan to support it that addresses some of these issues in the justice system. And it's on the way, is my understanding. So I think it's about seeing how it can support a long-term shift in the way that the justice system responds to these issues. It's not a magic fix. It's not, it's not going to sort stuff in the short term. It's not going to mean more convictions. It's not going to mean, and the term victims getting their day in court was used by earlier witnesses to this committee, and it's not about that. It's about people being able to be heard and issues that are not reaching the court being able to be discussed within the courts in Scotland. It's fairness. Yeah. Sorry.
Yeah, I very much echo what Lily has said. I think it is part of a longer-term picture for us. I think having access to judicial training, I think some of our wider prevention work in terms of changing the values and attitudes, I think the implementation of female forensic examiners will be a huge opportunity for people who before haven't been able to access the very crucial DNA evidence that can make the difference. I think it is about changing the culture of the courtroom and about affording rights. Much of the discussion about miscarriages of justice about the accused, but I think what about the rights of the complainer? And I know the Victims and Witnesses Bill, we have, there's been amendments proposed about independent legal representation, because where are the rights and the privacy of the complainer? When you're raped, in effect, your medical records can be accessed, your mental health, your sexual history, all of that is fair game in a court, and I think it's part of a much bigger push in terms of victims' rights. If we're looking at accused and strengthening those rights, I think they're not an either-or. You can be strengthening the rights of both to access to fair justice.
Thank you. We believe the removal of corroboration will actually improve and strengthen the criminal justice system in Scotland. It is linked to the wider public confidence in the system, but having it removed will actually lead to a better position for victims and witnesses.
Mr. Kelly.
I think we don't know. I think it's, sorry to be Donald Rumsfeld, but it's probably too many known unknowns. We can point to areas of concern, but we don't know about the effect that this will have upon the fairness, the overall fairness of the trial, and the overall fairness of the trial not simply in relation to victims of sexual crimes, but in relation to victims in relation to accused persons as a whole in Scotland.
Ms McCall.
I think we can probably all agree that the place we want to get to is a system in which the public is confident that the innocent are acquitted and the guilty are convicted through a fair process. Abolishing corroboration without looking at the system in the round, in our view, increases the risk that there will be unfair trials and miscarriages of justice, and it loses the opportunity to do just what Sandy Barton has just said, which is find the way forward to increase both the rights to an effective remedy for victims of crime and also the rights of the accused to a fair trial. So that opportunity is what will be lost.
May I end on that, John? Thank you very much. Thank you. That concludes it. And thank you very much for waiting. Thank you for your evidence. It was very, very interesting. And if you'll forgive me, I'm just going to keep talking because we've got to move on. I now move on to item 5, subordinate legislation. The one negative instrument, the Criminal Legal Aid Scotland Fees Amendment Regulations 2013, SSI 2013/320. This amends fees payable to solicitors for carrying out legal aid work in relation to solemn proceedings with a view to ensuring compliance with the European Convention of Human Rights. The Law Society has written to the committee stating that it cannot support these regulations on various grounds. Its letter can be found at Annex A of Paper 3. Now, if you've got a lot of comments, do you have comments on this? Right. So I'm going to give you the options. A member can lodge, because it's not just going to be passing through. A member can lodge a motion to annul, and we can take it next week. We could call the Minister or Cabinet Secretary, could be invited to give evidence next week. We could write to the Scottish Government and consider this next week with the issues raised by legal aid, which I appreciate what they're saying, think it's a cost-saving exercise, basically. Or the points can be noted on the record today. So if I can very quickly have your objection, first of all, which I think is probably what I've said, and what you want me to do.
Society makes some very strong points, and they raise in particular that this kind of shifting of the resources just might well bring about potential for further ECHR issues, and I think we need to examine that in detail.
So I think that's the issues raised. Do we want to do it per letter, per evidence, per what? Right for a reply from the Minister?
Should we hear from both sides what the Law Society's concerns are?
Well, the Law Society's concerns are quite clear in the letter.
Okay. Minister, then.
write to the Minister and ask to respond, and then it's up to members what they do with regard to process.
As to when the 40 days expires?
Beginning of January.
Beginning of January.
Right. So thank you very much for that. We now move into private session.